Yes,
May please, I beg to mention item number 27. I am not pressing this application.
27.
27.
Mr.
That's got to be.
S. Kataki, learned counsel for the petitioner, submits upon instructions that he is not pressing this case. On the prayer of Mrs. Kataki, the writ petition stands dismissed as not pressed.
Lordship, item number 26.
Yes,
Sir, has been infrastructure
Infructuous.
Right.
Mr.
harbor.
R. Barwa, learned counsel for the petitioner, submits that the matter has become infructuous. According to the writ petition dismissed as infructuous.
Item number 38 is concerned. Lordship has
30?
already 38.
38.
Yeah, Lordship has already passed the order in the main writ petition, that is that missing autonomous council.
Okay. Okay.
It has become infraction.
Okay, right. Item 38, you're right. In view of the order passed in WPC number. Just write Mr. Ardhar appears for the applicant. He submits that in view of the order passed in WPC number. Give me the IA. That is. In view of the order passed in WPC number 3559 of 2024, the present application has become infructuous. In view of the submission made by Mr. Ardhar, learned counsel for the applicant, the application is dismissed as infructuous. Yes,
May please, your Lordships. Lordships, I beg to mention item number 23 of today's list. Melons. Now, I am appearing for the petition. I have not been able to contact the client. Melons. So, may I be granted some time? Can it be taken up after the vacations? Melons? This is a challenge to a Bakijai proceeding. Melons.
5 years gone, 5 years have passed.
Sometime, Melons, I have not been able to contact them. So, sometime may be granted to
Mr.
S. Vishwakarma.
S. Vishwakarma prays for time to contact his clients as he wants to. He has not been given any communication with regard to the latest status to the case. Status report with the case. Accordingly, list this matter on to next week. End of next week. 27 September.
For listing of a writ petition, Lords. On 25th
Huh?
September, Lords. Listing of writ petition, Lords.
New one or old one?
Old one, Lords.
What about what?
Have a non-payment of bills, Lords. 25th
Give a date.
of life.
May it Lordship. Item number 28, infructuous matter.
Okay. Mr. S. Banik, learned counsel for the petitioner, submits that the writ petition has become infructuous. Accordingly, on the prayer of Mr. S. Banik, the writ petition is dismissed as infructuous.
May it please your Lordship, with the consent of other side, I beg to mention item 16 of today's list.
16.
I am for the petitioner. Lordship,
Yes.
can it be taken up after vacation? My senior is out of town.
Okay, right. On okay, what is the number that is come? What is the number of the wrong LCR? Okay, right. Mr.
Y. Kothari.
Y. Kothari, learned counsel, prays that the matter may be adjourned as his senior is having some personal difficulty today. Praise aloud, this is the matter out of vacation. As the wrong LCR has been sent from the Industrial Tribunal Kamru, that is number so dash, the same be returned back to the Industrial Tribunal Kamru.
May I please, my Lord? My Lord, I beg to mention this two items for listing in admission matter, my Lord.
When?
On 25, my Lord. My Lord, I have another prayer, my Lord. My Lord, I may be allowed to withdraw item number 1, my Lord.
Okay.
With liberty to pray.
Okay. Okay. Right. Mr.
P.K. Mazumdar, my Lord.
P.K. Mazumdar, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to file afresh.
On this one.
Miss D. Jane appears for the Water Resource
Yes,
Department.
for water
The
system.
prayer of the petitions council is allowed, read petition dismissed as withdrawn, with liberty as written.
May I please, your lordship? Lordship, I beg to mention item 24, lordship.
Yes,
Lordship, in this matter, we need instruction, lordship, up to date details, old matter, lordship. So, lordship may adjourn today, lordship. After vacation, it may come, lordship.
Huh?
After vacation, it may come.
no, why vacation?
We need some up to date instruction, lordship.
You take instructions by next week,
Next week, lordship.
next week. And then I'll dismiss your case if you don't have it. Mr.
J. Abbas.
J. Abbas, learned counsel for the petitioner, submits that he needs time to obtain instructions with his client. From his client with regard to GST and SGST from the running wheels of the petition. This is the matter. Give a date.
Obligement.
May I please, your lordship, my lord? Lordship, operative part of the order, your lordship will find.
Okay, right. Heard Mr. NNB Chowdhury, learned counsel for the petitioner, who submits that the order dated 4/3/2020, 14/3/2020. 14/3/2024 in WPC 4297 of 2023 has not been complied with. Issue notice returnable in 6 weeks. Petitioner takes steps for service of notice upon the respondents by registered post with AD within 3 days.
Yes.
This is the matter after 6 weeks. Heard Mr. N.J. Gogoi, learned counsel for the petitioner, who submits that the order dated 23/8/23 passed in WPC 6932 of 2018 has not been complied with. Issue notice for place. 663. Wait, I have forgot. Steps to be taken. Steps to be taken within, steps for service of notice by registered post with registered post with AD should be taken within 3 days.
Lordship, obligation.
I took.
May I please, your lordship?
Okay, right. Heard Mr. J. Sharma, learned counsel for the petitioner, who submits that the order dated 31/5/24 passed in WPC 3454 of 2020 has not been complied with. Same thing, huh?
I will be allowed to take justice service also.
First up, in addition to the above, the petitioner shall also serve notice upon the respondent by way of justice service.
Right.
In addition,
Please, my lord. My lord, non-payment of contractual fee amount, my lord. Here, my lord, earlier also we have filed one writ petition, my lord. And in that writ petition, the amount is 50,44,200.
so earlier that order was there.
Yes, my lord. And my lord, during the pendency of that case, my lord, 47,80,261 rupees already paid, my lord. Then, my lord, honorable court passed an order, and then, my lord, we have submitted the case before the authority concerned, but they have not released a rest amount of 2,63,959 rupees, my lord.
How much?
2,63,959 rupees.
Yes, madam.
Lordship, here they have not annexed the liability statement.
No, madam, this is the second round. Already a judgment has been passed earlier, order has been passed earlier.
Lordship, kindly grant us some time to obtain the instructions.
Liability statement, you forget it. Why don't you pay? Acha, you see this case, his case was covered by that that bunch of cases,
Yes.
by that. So now what to do?
Lordship, I need to obtain instructions.
Should we dispose and or you look to instruction?
Lordship, I will obtain
Dispose of one
instructions.
already admit.
Huh?
Can be disposed of, my lord.
Where is the admission?
Lordship,
Completion certificate I have annexed, my lord.
No.
At page 13, my lord.
Completion, sir, but what is the amount?
My lord, here the total amount is 1,59,44,220, my lord. And at this time, the pending amount is rupees 50,44,220. Then we have
That after, prior to coming to this court,
prior to coming this court.
and after the judgment,
After the judgment, now the amount is 2,60,959.
so they have not paid you this much. Yes,
Lordship, I need to obtain instruction. Actually, this matter has been disposed of on 27/9/2022.
yes, okay, you take, okay, right, heard, Mr.
ठीक है मुझे
P.K. Mazumdar, learned counsel for the petitioner who submits that the petitioner was given a work order in respect of the scheme inverted commas anti-erosion measures in P/B of river Mangaldoy to protection Mangaldoy town and its adjoining villages. Page 13, it is there. He submits that the total contractual dues payable to the petitioner was rupees 1,59,44,220. As the petitioner's contractual dues were not being paid, the petitioner filed WPC number
3913 of 2020.
3913 of 2021. The same was disposed of along with a number of writ petitions, the lead case being WPC 4734/2021 by this court on
27/9/20.
27/9/22 with the following directions. Page 20, red to red, okay. Next part. The petitioner's counsel submits that subsequent to the order, the petitioner has been paid most of his contractual dues, except for the balance amount of rupees 2,63,95. Miss D. Jane, appearing for the Water Resource Department, shall obtain instructions with regard to why the balance amount has not been paid to the petitioner till. Release the matter when?
After vacation.
Give a date.
Oblige.
Obligement.
Please, Your Lordship. Item number 6 and 7, I like, they pertain to non-payment of admitted contractual dues. 6 and 7, Your Lordship.
So what to do?
Your Lordship, in fact, the similar matters, the standing counsel for the PHE appears. I understand that she might be on legs today. Your Lordship can direct me to serve extra copies to the finance department. Respondent number 3 and 1, 2, 4, 5, and 6 are for the PHE.
So we issue notice.
Yes,
Heard Mr. M. Sharma, learned counsel for the
petitioner, Your Lordship.
petitioners who submits that the petitioner's contractual dues have not been paid till date. Issue notice returnable in 5 weeks. Mr. A. Chaliha accept notice on behalf of
Respondent number 3, Lordship.
respondent number 3. While who is the counsel?
Miss M. Kolita, Meghna
While
Kolita,
Miss M. Kalita, where is she?
she was here. I think she's caught up in some other court.
You
Might-
call her, we'll. While Miss M. Kalita accepts notice on behalf of respondents number 1, 2, 4, 5, and 6. List the matter after 5 weeks to enable the respondents' counsels to obtain instructions and file affidavit.
Great.
In both the cases, but let her appear.
Yes,
This is
yes,
case.
yes.
Yes,
My lord, I was issued, my lord, the work order means there was
work order dated,
that your lordship will see, but practically handed over to me in
the work order dated.
lordship. At page 28.
Yes, 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 33/21.
21. And practically given to me partially from January 22.
Three months
My lord. Initial for 3 months, but I was not given because of pandemic.
with effect from 1/4/21.
Lordship, lordship. And
NIT dated
NIT dated annex of 1, my lord, 25, page 23, my lord. 25 January 21. For 3 years. 24 serial number 3 BC in my lord. Serial number 3, page 24.
page.
Page 24 of the NIT, page 24, serial number 3. For 3 years.
But then the office order is of only for 3 months.
No, my lord, tender is for initial.
Tender maybe, but then
Initially, it's like this, my lord, 3 months, then subsequently they allow up to the
I
validity.
do not know. I don't know.
Thereafter, and they need to have executed an agreement that they have not done because of the pandemic. I was allowed to work, my lord, January 22. And then, my lord, without,
No, you have been allowed to work with effect from 1 April 2021.
but handed over to me, my lord, practically from January 22.
So
Hours, my lord.
then what happened?
Then, my lord, I moved the representation page 37, 38, my lord. For structure and the devices to be made, my lord, hygienic. That has not been done.
You wanted to close the premises. That is it. Canteen was handed over to us on April 12th. During pandemic, due to which we requested the concerned
to allow us
authorities.
to the premises, but we are asked to operate special condition.
Ah,
We have issued for the exemption for pandemic period, because then lordship kindly read the second. Secondly, it was mentioned that the agreement that was the infrastructure, electrical appliance will be taken care of by the department, which was again not taken care of until the present date. We were compelled to carry on our services in the same condition which were hard for us for extreme weather condition and hygienic infrastructure. That we have given on 39/22. Then, and I was practically allowed January 22 month. Then lordship kindly see page 38.
yes.
Lordship kindly see page 38, another representation, my lord, I have given to them. So, may I read, my lord? Number 1, in the year of the current contract started from 1/1/4/23 was unfortunately faced with the natural disaster of COVID-19, which instead most of all till month of January, resulting in providing with the business paid only about 3 months, for which also throw a lot of challenge in that the earlier calamity. Accordingly, we ready to pay the rent quoted above for so and so 1,24,000. And second year, for faced another major issues which were not functioning of the electrical appliances and especially an air condition and the,
Mr. Counsel, your contract was terminated.
my lord, we are not on terminated, my.
You are not terminated.
I'm
Then
not,
what are you
I'm
on?
not challenging, my lord, terminated.
Then
My only prayer is that, my lord, they have issued a letter, my lord, that page 41. They are asking for counting, my lord, recover all the areas.
correct. From when? From when?
Lordship will see page 41.
Hmm.
Direction was issued to recover from me.
Yes, how much?
It is, my lord, from that initial date till 31/3. First page, my lord.
8.2 lakhs,
My
is
lord,
it?
my lord.
Now, how much have you paid?
My lord, I
How
have,
much have you paid?
my lord, they have executed, they have not executed contract. I
Mr.
have not-
Council, you have used the canteen, you have used the building.
Yeah,
Have you paid any rent amount?
No, no, not.
You have not paid.
They did not receive. So my prayer is that, my lord, let them consider my representation before taking any action, my lord. We are ready to give 50%, my lord, because of pandemic, my lord, we cannot. They have not taken call on my representation 3 times.
No. First of all, you tell me, when did you start operation?
Operation practically January,
Not say practical, there's a very practically and
they
what?
did not hand over us, my lord.
But
They-
so practically means what? That, you see, there's one thing. Supposing this room is there. Did you use it or not?
No,
From when did you use it?
I used from January
January 22,
2022
till
till the termination.
till termination. So you are willing to pay from January 22 till termination.
Till termination 50%.
Why?
Because, my lord,
Why?
my
Why
lord,
there-
no, my, I'll
No,
just
no, no,
explain, my
there,
lord.
there's no case.
Required documents, required things, my lord, they have not given to us.
No, Mr.
SC also
Pre-
not working,
Okay,
appellants also
sorry.
not working.
Oh, madam, you're here. So, okay, so you'll be appearing for,
Item number 6 and 7.
yes, 1, 2, except for 3, everyone, I think.
Yes. Obliged.
So let them take a call on my representation, which I have submitted.
Why? You tell me why you should pay only 50%.
My lord, because of the pandemic, my lord,
What
I
do you mean
cannot run
pandemic?
business, my
No,
lord.
no.
They did not allow, my lord, without doing, my lord, they are asking money, my lord. That is not the fair, my lord. Till January, February,
No case.
February till.
You go to division bench. No case.
No, my lord. At
When
least,
the rent amount is 100 rupees
my lord,
per month,
my lord.
and you have admitted that you have occupied the premises and used it from January
22.
till January 22 till termination, for that period of occupation,
That I'll pay, my lord.
that you have to pay. How can
Then
you
I-
say that you'll pay 50% of that?
They are asking for 8 lakhs, my lord, from date of beginning, my lord. That is my,
No. How much are you supposed to pay every month?
every month, my lord, 34,000. What is it? And before.
Where is that? Let us see page.
Plus. 34,166, page 8, my lord.
Page 8.
8, my lord, I made a statement in the monthly run, my lord. But they need to have give, my lord, all the appearances in a suitable condition. And they did not execute the agreement also, my.
34166 per month.
My lord.
Now, you see,
Procedural.
so from January to December 22, 12 months. And then in 23, it is still 96. So 5 months plus 19 days. So 17 months, 19 days. Say forget this 19 days. 17 into 34166 will be how much?
I'll calculate.
Nah. It comes to more than 50%.
That consideration.
So anyway, I mean, you are willing to pay this 34,166 per month
For
from
initial 3 months.
from January 22 till termination of the contract.
No, my lord. Because of pandemic, my lord, I could not run, my lord. Past 3 months, I'll give
No.
full run.
Why? So why? What do you mean?
My lord, I was not allowed, my lord, in the name of me, it was there, my lord, pandemic period, how can I, my lord? And
No,
they did not
no.
execute the agreement also, my lord.
I think we need to let us issue notice. Let the not notice. Let some. I think let the other side say something.
Lordship kindly have a look.
Your petition is not very clear.
My lord, Lordship kindly see one thing, my lord, page 27, serial number 48, my lord, for a moment.
Yes. Yes.
The selected contractor will sign an agreement with the secretary SAD, include all the terms and conditions mentioned herein. Additional conditions may also during the process of the selection, including the agreement, but they have not done it.
I do not know, that is your stand. They might say that they wanted agreement, you are not
Yes, yes,
signing.
if
That
they
is-
can show, my lord, we got agreement, I have no.
So you have not paid 1 rupee also till now.
They are not receiving, my lord.
This court will receive for you.
My lord.
You
Past
pay.
3 months, I'll divorce.
No, you pay for this, you pay, you said you're willing to pay 50%, no?
My lord.
50% will be how much? Will be 34166 into 17 and a half months, huh?
50% of 17.
No. 34166 into 17.5 months, how much?
Yeah, correct.
17 and a half months, how much?
Into 17. Is equal to Kuman. 5,80,000 divided by 2. 50% holo. 2,92,000 50%.
You deposit 4 lakhs
Yes.
now, when?
Lordship.
Tomorrow?
Not tomorrow, my lord. 3 days time we granted.
By invoking section 7 and 14 of the Assam Public Premises bracket eviction of unauthorized occupants bracket close Act 1971. Next para. The petitioner's counsel submits that pursuant to an NIT dated 25/1/2021. Where is the NIT? 25/1/2021 for operating the existing officers' canteen at Assam Secretariat Complex, dispute. The petitioner had submitted his bid amount of rupees 34,166 per month. Correct?
My lord.
Full stop. The petitioner's bid being the highest or the lowest? Being the lowest,
Highest.
being the highest, comma. The petitioner was to be allowed to operate the canteen for a period of 3 years from the date of the award in terms of terms and condition number 3 of the NIT dated 25/1/2021. Next one. The grievance of the petitioner is that though office order dated 30/3/2021 had been issued by the Secretariat Administration Department, lowest bidder, not highest bidder, lowest bidder. How come lowest bidder? Huh?
My lord, maybe for the items, my lord, food item.
Okay. Initially for a period of 3 months. The petitioner was able to operate the canteen only from January 2022 till termination of the contract period, the termination of the contract, while letter dated 19/6/2023 issued by the General Administration Department. Joint
Without
Secretary,
that
Joint
too-
Secretary,
Without,
Joint Secretary, General Administration Department. Who's that? Next paragraph. The petitioner's counsel submits that the petitioner is not making any challenge to the termination of the contract. Full stop. However, as the petitioner was able to operate the canteen only from January 2022 and not prior to January 2022, the petitioner cannot be asked to pay rent for the period prior to January 2022. That is your case.
my
He accordingly submits that if the petitioner is to pay rupees 34,166 per month from January 2022 till termination of the contract, that is on 19/6/2023,
50%.
the petitioner would be liable to pay rent from January 2022. They have to pay rent for 17 months. No, for 17 months, 19 days. So you pay for 17 months, 19 days.
50% I'll pay, my lord.
Why?
Because I have not given, my lord, the required thing, my lord. Even AC also not working, appellants also not working, electronic also not. I have,
He submits that the petitioner cannot be made to pay the full amount, the full rental amount from January 2022 till 19 June 2023, in as much as the AC in the
AC
canteen,
not only
AC
AC, my
in
lord,
and AC,
appellants,
what else not working?
other electronics.
And other electronic items
were
in the
not-
canteen were not working.
And other things also, my lord.
Other thing, what are the other things? Tell me what
Other
other thing.
thing, my
Water, no water coming in, latrine not working,
Furnitures also,
all windows broken,
furnitures also.
no furniture also, everything cooking by hand,
My lord, in the pandemic time, they asked me, so,
no gas, all wood being used. What else?
my lord.
Where have you stated that in your
Yes, my lord.
in your
I have
application,
stated.
in your representation?
Representation I have stated.
Let us see.
Uh,
Non-functioning electrical appliances, especially air condition and fan.
my lord, I'll show. Lordship will see base.
When did you make your complaint? When did you make a complaint with regard to this?
3 complaints I have given.
Yes, when? Date.
Lordship, first 3922.
3922.
Ah,
And you started using it from January 22.
my lord,
So during the summer it was okay, no need of,
my lord.
you didn't complain.
My lord, SC is not that much required because
Not
it is for
required.
the customer.
Okay.
Appliances, my lord, because they need a fresh and hot, my lord. The microwave type.
So
That is also not work.
they have to provide everything.
Yes, they have to provide everything as per terms condition,
We'll see, we'll see,
infrastructure and everything.
we'll see. Okay, we'll see. Next para, Miss, who's the council actually? P. Nair. And P. Nair. Okay, all right. No one appears for the GAD and PWD. Was there any notice in as much as their names are not shown in the call list? Accordingly, list this matter on Tuesday. 24th, list this matter on Tuesday. Registry to reflect the names of Mr. P. Nair and Mr. D. Nath for PWD. But for Secretariat, who?
GA Assam General.
Yeah, for JD, who? You show council. Okay. JD. 25th.
Item 9, my lord.
Same.
No, my lord. This is relating to the non-payment of higher charge.
Okay. Right. Right, Mr. Jaya Barbuya, learned counsel for the petitioner, who submits that the higher charges of vehicles amounting to rupees 1,23,86,900 has not been paid. Issue notice returnable in as 5 weeks. Mr. S.S. Roy accepts notice on behalf of all the respondents. List the matter after 5 weeks to enable the respondents to obtain instructions and file affidavit if necessary.
My lord, pendency of the case may not be barred.
Pendency of the case will not be a bar for the respondents to pay the admitted contractual dues to the petition.
Lost.
Maybe, my lord, here, dismissal workman, my lord, from me, tea garden. And way back in 2010, then the reference was made by the government and 2012, my lord. Ultimately, the award was passed on.
No, what is your case?
Yes, my lord, because there is an allegation, my lord, that 50,000 kg of, for the 5 trucks, tree was missing from the godown.
Acha. Your item 10.
Yes.
You're dismissed from service. So notice has to go. Heard Mr. R.P. Sharma, learned senior counsel, assisted by Miss.
It's
Yes.
Goswami.
Huh?
KD Sharma.
A.D. Sharma,
Yes.
learned counsel for the petitioner, who submits that the judgment and award dated 5/7/23 passed by the learned presiding officer, Labor Code Guwahati, in reference case number 5 of 2022, whereby the termination of the petitioner's dismissal of the petitioner from service has been upheld, should be set aside. Admit the issue call for the LCR. Issue notice to the respondents.
Respondent number
Returnable in 6 weeks. Mr. S.S. Roy accepts notice on behalf of
2 and 3.
respondents 2 and 3. Petitioner takes steps for service of notice upon the respondent number 1 by a registered post with AD within 3 days. This is the matter after 5 weeks.
How does it?
Grievance of the petitioner pertains to the rejection of the technical bid pursuant to the expression of.
On what ground was it rejected?
For non-supply of work orders for 2 particular periods. What the EOI
Where
stipulated
is that? Where is that?
at
Impugned?
page 32, Lordship. 32 is the minutes of the technical committee, and the operative relevant portion regarding rejection of the petitioner's bid is at 33, serial number 7.
Okay,
33 serial number 7, work order copies.
so
not
this
sub-
is required.
Yes, what they say is, but we have submitted everything.
Now now the problem, madam, that is a disputed question of facts.
Lordship, if the records are called for, Lordship will kindly peruse the EOI once, what they had asked for. Page 21,
Yes.
and the documents that is required. Relevant page, page 22, detailed particulars papers which have to be submitted by the NGO, public institution, public body. As regards the documents regarding.
Past experience.
He said, yes, past experience. If you're not serial clause C, serial number 6 is one of them. Should have past experience in supplying supplementary nutrition food during each financial year of 1920, 2021, and 21-22 in the Government Department of Assam. Work order copies along with completion certificates sealed and signed by the.
So work order copy is
Yes.
not submitted.
Lordship will kindly peruse the next page once. Page 23. Annual report of the last 3 financial years, that is 1920, 2021, and 21-22 of the NGO, public institution, or public body panchayats. Then if we can skip over serial number 8, serial number 9. Proceedings of the last 3 financial years, 2019, 20, 2021, and 21-22 of the annual general meetings of the NGOs, public institutions, etc. Then serial number 10.
No,
And-
madam, that is not the issue. The issue is, look,
Lordship,
let us
why-
not digress.
Why am Lordship pointing it out? Just this one, this clause.
Ah.
This is the last one I'll be referring to. NGO, public institution or public bodies, panchayats, self-help groups must be reputed NGOs, public institution or public bodies, and should have work experience of at least the last 3 financial years in the field of social services. What it stipulates is that at least 3 years. In fact, these NGO, they have experience in this particular field for more than 10 years onwards. And we have.
Madam,
all
madam,
the
madam,
documents.
madam. There are interpretations given to terms and conditions of a tender by you. And then there's the interpretation is given by the author of the tender. Now, when the author of the tender at serial number 6 has categorically stated that work order copies are necessary. Now, can this court, when considering all the judgments of the Supreme Court, can this court say that no, the interpretation given by the author is not relevant? How can it be?
Lordship, there is one more aspect, whether that condition is directory or.
That issue has been settled by the Supreme Court.
Yes.
That is for the author to decide, not us.
Lordship, what we say is that we have enclosed everything, even.
That
the,
only that issue can be gone into, but that is also a question of fact.
Lordship, if the records are called for, everything will come out. Because 1920, 2020, and 1920 days, they have admitted that we have.
2021 and 21,
Yes,
22 is not there.
2022, I do not know why they are disputed, because we have, if your Lordship kindly peruse.
Is it here in your writ petition? That
If-
2021, 2021, 22?
Peruse the annual progress report here.
No,
page
madam.
42.
You see, there's a difference between annual progress report and work order. Work order is different.
Along with that annual progress report.
Sorry,
we
sorry.
Submitted the relevant documents.
I don't know. You see, just my question to you is, please do not try to beat around the bush. My question is very direct. Do you have copies of the work order that you had allegedly submitted with your tender document as an annexure in this writ petition?
It's a petition. Lordship, I'm very sorry, those particular documents we. did
Are not there.
disclose, But we have those documents.
You have those documents.
We received late, Lordship, that is why.
Huh?
They said received lately.
Who received late?
Lordship, from the petitioners, from the clients. That is why we could not enforce. Lordship, the documents are not given. That they have been supplying these particular food materials under the supplemental nutrition program in children's homes.
No, this is not a work order, Miss Madam. These are not work orders. Order for supply, what, these are not work orders. I am to inform you that recipe for supply of supply till so as per. This is the recipe for supply of this. No.
Lordship, the fact that we have been supplying these food materials
Huh?
under the supplemental nutrition program, that is what it mandates.
You see, Madam, you have to give them your basic case is that you have annexed the work orders in your tender document. Now, to prove your case, you have got to show in your in your writ petition
Understood.
that these are the documents you supplied. Now, this doesn't appear to be a work order. No, issued by superintendent's children home, Jorhat.
Yes, those are
Is the superintendent a government? Can you issue a work order?
government.
I doubt. It should be from the directorate. This cannot be. Sorry, this is not a work order. I've never heard of superintendent of a children's home issuing a work order.
I think Lordship, in
This is not a, if you say this is a work order, then and break up why nutrition foods are for supply of so and so. No, there's nothing, no amount, what is to be supplied.
Lordship, what appears from the UI is that they want experience in that field. Whoever experience in that field, and we have.
This is, you see, you give me a photocopy of this. This is also 4/1/21. 3/1/21. This page 28 to 30. Page 28 to. Actually, you have to give this. It's too many. This is not a
Yes,
work
Lordship.
order. Just show it to Mr. the thing. These are not work orders.
Lordship, what the UI mandated said that they have got to, purpose of that is they have to got
Sorry.
experience in that particular field of supplying these.
If you want to have it, if
materials.
you're not giving me, then I will have it Xerox and I'll dismiss your case
Lordship,
straight away.
we can supply, furnish those copies, or we
Ye-
file an additional.
No
affidavit
need.
endorsing this.
I'm going to dispose of the entire case now. There's nothing here, madam. That is not a work order.
From not a government department.
That is not a work order.
It's a case. Yes. Okay, wait a minute. Huh? Okay.
And where are those are not work orders.
Lordship, these are the kind of documents we had enclosed.
No,
along with the-
madam, those are not,
annual-
you know very well. Work orders for, by the social welfare department and women and child, in fact. Because women and child, these are issued by the directorate, not by some children's home. Because those goods are for the children's home.
Yes. Now, we are trying to, Lordship,
No case, madam.
what I'm trying to submit is that they have experience in that particular.
They have
field.
experience.
Yes.
They have experience. But you have not, you don't have a work order. So what is wrong? There's nothing wrong.
Government department probably.
That's not a work order, madam. You give it to me, I'll have it photocopied. Yes. And I'll make it a part of the record and we'll dismiss your case. Or you want to withdraw, I'll allow you to withdraw. That's all.
Lordship, for withdrawal, I have to seek my client's permission.
Then I'll dismiss your case. So give me. We do not take long. It is there. He's not giving. He doesn't want to give now.
I'm ready to give. I'm ready to give. That is why I've furnished this before the.
Okay.
They have sufficient experience, and that is what the UI
So
meant.
your case is basically you don't have work order, but you have sufficient experience. That's your case.
And that is what the clauses of the UI appears to convey.
Yes, yes,
That
but.
one should have, because what they
Huh?
say is that clause, particular clause says
Ah,
is that at least 3 years, at least 3 years. That is
But-
beyond 3 years,
so you're admitting that you don't have work orders.
those are the documents. Those are the
So
documents.
these are the, okay, right. Heard, Miss.
And they can also confirm it from the documents which you have. endorsed,
Madam,
whether
this is
these are there.
completely the decision of the state. AFCONS is there. There's so many judgments of the Supreme Court as to who is the best interpreter of the terms and conditions of a tender. It is their money. They want to spend it. They want to interpret their document. They made the tender condition.
I understand.
What is there? There's nothing there. All right. Heard Ms. D. Boramahan, learned counsel for the petition, who submits that the petitioner submitted its tender. Petitioner submitted their tender in response to the notice inviting expression of interest dated 18. No, hereinafter, it dated 18/11/2022, hereinafter referred to as the NIT. For supply of cereals and pulses under the Supplementary Nutrition Program bracket SNP from NGOs/public institutions or public bodies/panchayats/self-help groups/cooperatives during the financial year 2022-23. The case of the petitioners is that in terms of clause C bracket Roman 6, small, of the NIT, the NGOs slash public institutions or public bodies. Now, just say the bidders were to have past experience in supplying supplementary nutrition food during each financial year of 2019-20, 2020-21 and 2021-22 in any government department of Assam. Full stop. Work order copies along with completion certificates sealed and signed by the competent authority for the same should have to be submitted. Now, should be submitted along with the technical bid by the bidders. Full stop. Next part. The petitioner's counsel submits that despite work order copies for the year 2020-21 and 2021-22 from government departments having been submitted by the petitioners in their tender documents, along with the tender documents, the petitioner's technical bid was rejected on the ground that work order copies for 2020-21 and 2021-22 from government departments had not been submitted. Next, the petitioner's counsel submits that the original records should be called for to ascertain as to whether the petitioner had submitted work order copies for 2020-21 and 2021-2022. She also submits that as the various documents of the petitioner in the tender documents prove that the petitioner had past experience in supplying supplementary nutrition food for the financial years 2019-20, 2020-21 and 2021-22, the same should have sufficed in the government coming to a decision that the petitioner's tender documents was in terms of the requirements of the NIT. Mr. S.S. Roy Leonard, counsel for all the respondents submits that when the petitioner's technical bid has been disqualified on the ground that the petitioners had not submitted their work order copies for the year 2020-21 and 2021-2022, the denial of the same by the petitioners showed that the issue pertained to disputed questions of facts. I have heard the learned counsel for the parties. As can be seen from the submissions made by the counsel for the parties and the averments made in the writ petition, the issue pertains to whether the petitioners had submitted their work order copies as required under clause C bracket 6 of the NIT. And a comma which is as follows, which states as follows. Now you take it down. Page number 22, last para. Next para, right? Clause C speaks of the detailed particulars / papers which have to be submitted by the NGOs / public institutions or public bodies / panchayats and self-help groups / cooperatives along with actually you put the C also you put, C and the 5. It's already there. Next. As can be seen from the above, the only question is with regard to whether the petitioners had submitted their work order copies along with the tender documents. In this regard, now as the petitioner had not, as the petitioners have not annexed any of the work order copies for the year 2020-21 and 2021-22 in the writ petition, the counsel for the writ petitioner was asked to furnish a copy of the same to this court. In regard, in persons to the above request made by this court, the following documents have been submitted, which are photocopied and are made a part of the record as annexure X dash annexure dash annexure X dash 22 to annexure dash to X dash 39. So it will be from page 22 to 39. Okay. And next para, annexure X dash 22 and X dash 23. No, the contents of annexure X dash 22 and annexure dash X dash 23, which is also similar to the other annexure X 24 to annexure X dash 39 is reproduced herein below as follows. So you take this 22 and 23. The letterhead of the annexure X dash 22 to annexure X dash 39 shows that the letter has been written by the Superintendent Children Home Jorhat, which is run by Shankar Madhav Christi Bikash Kendra. This document in no way can be said to be a work order issued by the government. Further, there is nothing to show the quantity of requirement regarding the quantity of requirements of supply of cereals, pulses are required under the supplementary nutrition program to be run by the government, but to be run by the Directorate of Women and Child Development, SM. As next para, in the case of AFCON's the Supreme Court has held that the author of the tender documents, okay. Next para, in view of the restatement, this court does not find any ground to interfere with the rejection of the petitioner's technical bid, inasmuch as the petitioners have not complied with clause C bracket 6 of the NIT. The writ petition is accordingly dismissed. Let's take a photocopy.
Lordship, I'm on behalf of S. Bora Lordship. Password about time being Lordship. It's just in another
Item
12. Password for time being on S. Bora.
This case, Lordship, a tender was issued on 6/6/2024 for settlement of market Gohat, Parghats, etc. Lordship for the year 2024 and 2025. Annexure 1, page 13 is the
settlement market for 1 year.
for 1 year, Lordship.
From which period?
From 2024 to 2025.
Then what happened?
Then what happened, Lordship? The tender market committee has prepared a comparative statement, and the bid value offered by the petitioner was 85,001 rupee, whereas the private respondent number 6 has given 73,341. And with him,
Where is that page?
at NIT, Lordship.
No, where is that comparative
Yes,
statement?
Lordship.
Page 19.
Page 20, Lordship, the original one,
Page 20.
Lordship. Here also comparative statement, serial number 5.
Where is the 85,001?
Yes, sir.
And the other was 73,341.
Yes. And down below, Lordship, left hand side, serial number 5 approved.
Where?
See, page 20 down below.
Serial number 5 approved.
Yes, approved. But
So serial number 5 is you.
yes, Lordship.
Then
Then, Lordship, work order, Lordship, the Indian order, work order, Lordship, will find at page 21, side copy. Serial number 7, Lordship, that Athiabari bi-weekly market was settled with the private respondent, Ratan Boro.
Ratan, where?
At page, serial number 7, Lordship, at page 21.
Ratan Boro. Okay.
Yes. This is the private respondent.
Yes, madam.
Lordship, after preparing comparative statement also, market settlement committee has right to re-verify the document.
Maybe.
Lordship. Because sometimes it happens, Lordship, someone giving demand draft instead of bank draft, Lordship.
Maybe,
Lordship,
then-
I need 2 days time to take instruction, Lordship. Till then, no stay order.
Lordship, what by learned principle?
By Monday, Lordship, I shall.
Absolutely, apparently on the face of the record, it's a colorable exercise of power, Lordship.
2 days will not
Absolutely
make any
colorable
difference,
exercise.
Lordship. I shall
Huh?
take instruction.
Absolutely
I shall take
colorable
instruction,
exercise of
Lordship.
power. I had stated.
Monday.
let her come on Monday.
Monday.
Monday, if no explanation, proper explanation, straight away stay.
Absolutely colorable.
Correct,
exercise.
correct,
Not by
correct.
intention, Lordship.
Yes, madam.
Only
yes.
2 days,
Absolutely,
Lordship.
Lordship.
Let me.
Lordship, if Lordship,
Take instruction.
please passes the.
No, because you see out here,
I
he's
was-
quite correct because comparative statement is here. And he's 85. There is no reserve price also. Nothing is here.
Lordship, but there might be some reason.
No,
I
no.
just for satisfaction of me, Lordship.
No,
Only
no,
Monday.
no, not for your, not for your satisfaction. This
Lordship,
code is not functioning for your
I shall
satisfaction.
satisfy, Lordship, if there is some reason, Lordship.
There are
I do not know if, see this
document
document,
goes to
Lordship.
show that I have been approved, Lordship, by the marketing settlement committee.
Only 2 days will not make much difference, Lordship.
He will
Monday,
lose.
Monday.
It may
Monday, Lordship.
make a lot of difference, Lordship, even one day,
Because Saturday market is there.
Lordship,
Saturday market is there.
bi-weekly, Lordship.
Bi-weekly.
Till Monday, Lordship, kindly, Lordship.
Lordship, till then, Lordship, till then,
If I could
Lordship,
not satisfy, Lordship, Lordship is leave. I will-
Okay, till Monday only, Monday. Then we'll dispose of.
till then, Lordship, till then. Lordship is always.
No, Lordship, kindly Monday, till Monday.
Why is she is objecting, Lordship, when there is on record, there is documents to show that, yes, I have been approved with. Why my learned
This
is
status
objecting
quo.
so much, Lordship? I don't know. There should be something, some fairness in.
Yes, actually,
submission.
because it's quite clear. He's the highest.
Yes,
But Lordship,
Yes.
there might be some reason, Lordship. Only 2
Reason?
days I am praying, Lordship. Kindly, Lordship.
what reason?
When was the petition given to you?
Petition.
We'll take it up at 2.
Yes, Lordship.
We'll take it up at 2 o'clock. You call them.
Yes.
2 o'clock.
Keep you.
Problem.
Yes, what are you challenging here?
Lordship, this, that government notification cancelling the settlement process and subsequent extension, Lordship. I am now confident.
Yes, Mr. Datta, what is happening? You are not taking any action.
Yes, that is correct, my lord. We are,
I think
These matters, my lord.
we'll set aside your
these
26.
matters are fixed on 38th, my lord.
Where?
The other matters, my lord.
By this court?
Yes, my By
On
another court, my lord, on 30, my lord. 38.
38,
Yes, 39, my lord.
39.
Yes, as
By-
a son's almost, my lord.
By Justice Arun.
No, court number 10, my lord.
But who's court number 10?
Made him.
Honorable
Justice, Mr. Mayor.
Because you cannot
Yes,
keep on,
that
it's
is
it's too much.
We are also expecting, my lord, from the cabinet, my lord, so that we can issue the tenders. my lord.
Okay, right. Heard, Mr.
MQ, sir.
MK Hussain, learned counsel for the petitioner who submits that the NIT that has been issued for settlement of the Kushtoli weekly market has been cancelled, has been cancelled by the impugned notification dated 29/6/24 issued by the Principal Secretary to the Government of Assam, Panchayat and Rural Development Department. However, the earlier settlement holder has been allowed to operate the market in violation of
Section 105.
105 of the Assam Panchayat Act 1994, as well as Rule 47 of the Assam Panchayat Financial Rule 2000. He submits that similar matters have been taken up by this court, and one of them being WPC 3613/2024, wherein
Page 38, Lordship.
Last piece,
Wherein
paragraph 10.
this court has state a part of the impugned notification dated 29/6/2024, which is to the following effect. Page 38, para 10 in italics, this is there. Full stop. He submits that the concerned unchallenged charge should accordingly run the market in terms of section 105 bracket 5 of the Act till till the disposal of the writ petition. Full stop. Mr. S. Datta, learned counsel for the PNRD, submits that decision is expected shortly from the government with regard to the new NIT conditions.
Model NIT.
Model NIT condition, model NIT to be made by the state government. Full stop. On considering the facts of this case and the facts in WPC 3613/2024, the court is of the view that the interim order passed in WPC 3613/2024 should also be passed in the present case. Full stop. Then character and you take it down. Consequently, you take it this down. No? And then who is the respondent?
Private respondent is there.
Ex-lessee maybe.
Ex-lessee, previous lessee.
So he's been given time till what? Till which date he's been given?
And Lordship, notice may be issued. His private respondent is there, Lordship. And
You can serve Dusty also, my lord, so
Dusty
that
also.
this can be fixed on 30th, my lord.
Yes. That can. It's private.
Today is what date?
20, Lordship, 10 days.
It is made clear that no further extension of the settlement of the market should be given to the respondent number
6.
6. Beyond 30. Beyond 39/2024. Full stop. Issue notice returnable in 10 days.
My lord,
Otherwise, this common judgment will follow. Lordship.
No, but the problem is you have to give notice to the other side. No, that is the problem. Issue notice returnable in 10 days. Mr. Datta, accept notice on behalf of
1 to 5, my lord.
1 to 5. Petitioner will take step for service of notice upon the respondent number 6 by registered post with AD within the course of the day, if possible, within the course of the day. In addition to by Dusty service within a week. List the matter on first. 1st October. Let that finish, then we can dispose it of same like.
Then it will be state directly state.
That's why I've said it. Not said, I've said it till
Beyond.
Yes,
till
yes,
30th only.
yes,
Because let him come. Beyond 30th, so that by 30th at least he'll come.
yes, yes.
Then Lordship notice may be given by giving a long day.
Huh?
2 weeks time given to.
No, let it come. This is all
Yes,
right.
yes,
Till
that case has
30th
been
only,
covered,
because
case-
this month, let him finish this month.
Yes, yes. All right, man.
Deal with the party and 50.
May please, Lordship. My lord, I want to implement
Huh?
as respondent number 6. Is my lord.
Mr.
I-
Counsel, who do you want to implement?
My lord, as because my lord, the money paid by that department.
So you made the secretary to the government of Assam, not the department. Look at who you want to implement. You want to implement the department.
My lord, represented by the principal secretary, my lord.
State of Assam is already there.
My lord.
Then it's never done like this. Look at CPC, give me CPC. Look at 79, 80. Anyway, look, you see, what happens is like this. We say that state of Assam represented by so and so.
Yes, madam.
Then number two, you don't say, then you don't go to the department and you say, department represented by so and so. And department, it is usually secretary,
Yes, madam.
so and so, or then the director, that department. So now what will happen otherwise?
May I allow to correct, my lord?
By hand you cannot, that is the problem, because of the new the new system that is being followed. That cannot be uploaded. You have to file an application and that has to be uploaded. I do not know if this is correct, so I don't mind allowing, but then I don't think this is correct, that's the thing. How do you, how now later, supposing it's not complied with, now who will you make a party? Everyone is departmentally, only the departments are there. You have got to make secretary to the government of Assam, so and so, then the department.
Yes. That is there in my petition, but my lord, it is inadvertently that mistake has been made.
So better you withdraw and you file a fresh application.
My lord.
Okay. That's fine. Mr.
K.U. Ahmed.
A.U. Ahmed, learned counsel for the applicant. Says that he may be allowed to withdraw the application with liberty to file a fresh application. This D. Jain appears for the
Respondent number 1 to 4.
1 to 4, while Mr.
S.R. Burra for respondent number 5.
S.R. Barba appears for pair of the petitions. Applicant's counsel is allowed. The application is dismissed as withdrawn, with liberty effect.
Obliged.
This matter is a adverse action of the CMC matter by locking my restaurant. My lord,
On what ground? Where is that? Where is that? Where is the impugned order?
interim order is my lord in page 25. And same day they locked the restaurant.
So now you have got a valid license?
Yes, my lord, it's next in
Next day.
next day,
Next day.
on next day.
So what to do? Let
My lord. He is a habitual lordship will see the, he earlier also have done, give a check to GMC, that bounce, thereafter he paid it again. Then again he took a license, continued. Then again he didn't renew it. Again he is caught.
anyway, whatever he has to pay, let him pay.
Let him pay, my lord. We don't know.
How much is it?
Moment he pays the amount, this
You,
is the.
you pay the penalty.
I paid already. my lord.
You paid already.
Earlier, that is earlier.
No, now.
Now itself I will pay. In Excel, 21.
So how much is he supposed to pay?
Well, that calculation I have, that inspection I don't have it, but they have to pay that fine part.
He wants to pay, so please give the amount, let him pay.
Well, they will approach the office and they will.
Let him pay, let him, you file an application, then you go there. We'll tell him to dispose it off within 3 days.
Moment the amount, only fine, we have to
Ah.
reseal it. There is no way out.
As per instruction, my lord, I would pay 1,20,000 and the receipt which also includes here with. My lord.
I do not know how much you have to pay.
You know,
That's what they will decide. I do not know. You cannot say how much you will pay. That is there. When was your trade license given to you?
Lordship will find the next day, the moment he is caught, next day,
Next
Lordship
day.
will find the trade license page number 30. Not
30.
Yes, 30. He was not on 5/9, 6/9, at 12 o'clock, he takes out.
698. Okay.
Takes out.
Okay, right. Right. I heard Mr.
And Burman.
N. Burman, learned counsel for the petitioner who submits that the petitioner is running the restaurant called the Urban Paradise. He submits that the said restaurant was sealed by the Guwahati Municipal Corporation by notice dated 5/9/2024 on the ground that the business was being run without a valid trade license. The petitioner's counsel submits that a fresh valid trade license has been issued by the GMC to the petitioner on 6/9/2024. Accordingly, the petitioner should be allowed to open his restaurant after all the required penalties are paid by the petition. Next paragraph. Mr. S. Bora, appearing for the GMC, submits that the petitioner should approach the GMC with a representation along with the valid trade license.
Pay the fine.
Already
submitted.
submitted.
Post up thereafter. As and when the petitioner pays the fine,
Repeated fine.
comma, if any, payable to the GMC, comma, the petitioner's restaurant will be opened for business.
Resealed one.
Will be desealed for business. Post up. Next, in view of the submissions made by the counsels for the parties, and keeping in view the fact that the petitioner has obtained a fresh trade license on 6/9/2024, comma, the petitioner is given the liberty to approach the GMC authorities for desealing his restaurant. Full stop. Accordingly, the petitioner is given the accordingly, if the petitioner approaches the GMC authorities with a request to reopen, to deseal his restaurant, comma, the same should, the GMC should allow for the same after all the required fees / penalties are paid by the petitioner. The same should be the prayer for the entire exercise for desealing the restaurant should be completed within 2 days from the date of receipt of the application for desealing the restaurant, comma, provided subject to the condition that the petitioner pays all the required fees and penalties paid. The petition is accordingly disposed.
In fact, we didn't caught him. He's running also a spa. That was also without trade license. He later on next day he got the trade license of the spa also. All were earning, which was only the restaurant.
Making money.
Yes.
I am preparing for response number 1 and
1 and 2. Mr. S.R. Barwa appears for response number 1 and 2.
Deeply obliged.
This petition has become infructuous.
Huh?
This petition has become infructuous.
Okay. Mr. N.J. Katanel, learned counsel for the petitioner, submits that the writ petition has become infructuous. Mr. R.R. Gogoi appears for the Excise Department. Yes, there also. While Mr. J. Patwari appears for point number 5. Mr. S.R. Barwa appears for Okay, full stop. Next. India the-
S. Diffusa. Appearing on behalf of D. Chaudhary, Your Lordship.
What is the name?
S. Diffusa.
Yes?
Diffusa.
Diffuser. You got the name?
DIFUSA.
DIFUSA.
Yes, Your Lordship.
Appearing on behalf of Mr.
D. Chaudhary, Your Lordship.
D. Chowdhury, counsel for the petitioner, submits that the writ petition has become infructuous. Mr. S. R. Baru appears for
All the respondents.
all the respondents. In the submission made by the counsel for the petitioner, the writ petition dismissed as infructuous.
Obliged, Your Lordship.
Infructuous.
Your Lordship, we need 2 weeks time to file reply in this matter.
19. NIT of 2014, madam. I don't think there's anything. Just tell me about the case. You tell me about the case.
This matter, Your Lordship, NIT was floated in 2014
For how many years?
for 7 years.
For 7 years. Then what happened?
Thereafter, Your Lordship, we participated.
Then?
Thereafter, Your Lordship, there were several rounds of litigations which took place. And subsequently, Your Lordship,
No, several rounds, forget it. Was the fishery settled with anybody?
yes, Your Lordships, initially, settlement was given to the fifth highest bidder.
To
To the fifth highest bidder.
fifth highest when?
If Your Lordship please, the first judgment is Your Lordship.
Since 2014, no other tender has been floated. Tell me, you read after some time, you'll be ready. I'll try to dispose of this case.
20 and 21.
Infructuous. Yes. Mr.
A. Ali.
A. Ali, learned counsel for the petitioners in both the writ petitions, submits that the writ petition has become infructuous. So Mr. S. Datta appears for the PNRD department, while Mr. S. R. Baru appears for
The district commissioner.
for the district commissioner. The district commissioner, and on the prayer of in view of the prayer made by the petitions council, the writ petitions are dismissed as infructuous.
Obliged.
22.
22 also have become infructuous.
Okay, right. Mr. A. Ali, learned counsel for the petitioner, submits that the writ petition has become infructuous. Mr. S. R. Baru appears for the district commissioner.
And then for all the respondents.
For all the respondents. In view of the submission made by the petitions council, the writ petition is dismissed as infructuous. And next year. X 22 to X to X. So you just make it X 23 24.
25.
22. They're not there. 22. Item. 22. Finished. Okay. Okay. Then 25. Fishery settlement 2012. Okay, right. No one appears for the petition on call. It is noticed that on the last date, that is 18/12/2020, no one had appeared for the petitioner either. The matter pertains to settlement of a fishery on the basis of and the basis of a settlement order of a fishery for 7 years on 4/10/2012. As no one appears on behalf of the petitioner, it appears that the petitioner is not interested in pursuing the matter. So stop. The writ petition is dismissed for non-prosecution.
29.
Yes, madam.
Lordship, here, the petitioner has not annexed the liability statement. And your lordship, according to our instructions, the department has already paid 25 lakhs to the petitioner.
25 lakhs
They
paid.
are claiming for around
Yes, my lord. Payment has been made.
49 lakhs.
Yes, so the remainder is 24 lakhs 35,000 something.
34, yes, your lordship, 24 lakhs 34,400 and
35,000, no? It'll be 35,000. 35,483. So what about this?
My lord, now, the case was filed for rupees 49,35483.
Correct.
But now, my lord, we have liability statement got from the
Come
department.
down.
That is amounting to 24 lakh 34,000.
How come it be 34 when it's 35? How come it is? So, okay, anyway, so according to department is 34.
Yes, yes.
Where is that? Where are they admitted?
That was.
We have not filed our affidavit. And your lordship, they have not made Minister of Jal Shakti as party also.
My lord,
Without Jal Shakti, you have paid him anyway.
Then we have to file and review petition for that.
Why?
Lordship, it's-
work order for.
This is not a part of the writ petition.
No, that was obtained after filing of the.
So where is the forwarding letter?
What is it?
You please file an additional affidavit. Okay. You file an additional affidavit. Okay, right. Heard, Mr.
DK Jain.
Huh?
Deepak Kumar Jain.
DK Jain. Oh. You also you're D Jain.
Diksha.
Country cousins. Okay, right. Heard Mr. DK Jain, learned counsel for the petitioner who submits that the petitioners that at the time of filing the writ petition, the contractual dues payable to the petitioner was rupees 49,35,483. However, during the pendency of the present case, rupees 25 lakhs has been paid to the petitioner. 25 lakhs or 25? 25 lakhs has been paid to the petitioner. Mr. DK Jain submits that in the meantime, the executive engineer Guwahati East WR division has submitted letter number GED/A-181/PT- Roman 2/25 dated 29/12/2022, which is to the effect that the pending liability of the petitioner amounts to rupees 24,34,448. 24,34,448. He submits that he will file an additional affidavit in this regard within a week. Accordingly, leave this matter, leave after a week.
Bless.
Give it back to him, that document here one.
Item 34 order.
Yes, what is to be done?
Lordship, in this matter, we were led by late senior counsel, Mr. S.N. Sharma. So Lordship may kindly give us 2 weeks time to take instruction from the client, whether they want to engage in new senior counsel.
I'm for the workman, my lord. This writ petition is against an award passed by the labor court. My lord may fix this matter for final hearing after Puja vacation in the meantime, because it has come for order. I'm also not prepared for the hearing.
LCR is a problem.
Nice.
It's somehow lost, I think, it's somehow misplaced.
Was an 11 on. Okay. Lordship will post this matter after the vacation. In the meantime, we will also try to get in touch with our clients also, my lord. a long time. We do not know whether these workers are alive.
Heard, Mr.
L. Sankamar.
L. Sankam,
Lordship.
learned counsel for the petitioner, who submits that the earlier senior counsel representing the petitioner has expired, and as such, he needs time to obtain instructions as to whether the as to whether no as to no with regard to engagement of a new counsel. Pushpa. This matter, no, Mr.
S. Chakrabarti for the workmen.
S. Chakrabarti appears for the work. This case pertains to a challenge made to the award dated 19/8/2008 passed by the learned presiding officer, Labor Court, Dibrugarh, Assam, in reference case number 18 of 2000. By which it has been held that the management were not justified in terminating the employment of the workman and was accordingly entitled to reinstatement with full back pay. So, sir, the writ petition had been filed on 22/2/2010. So, sir, office note dated 13/9/24 states that records of reference case number 18 of 2002 was received on 14/5/2010. However, there is no office note regarding tagging of the LCR with this case record. The LCR has somehow been misplaced and has not been traced out despite the best endeavor of the registry. So, sir, next one. Now what to do? On considering the fact that 14 years have elapsed from the time when the LCR was received by the registry of this court. This court is of the view that an attempt should be made to reconstruct the LCR. By whom? By the registry.
We will also try to find out because it consists of the evidence and the orders passed.
That is what. But then how will you record? Where is the question of reconstruction of evidence? That's the problem. Whatever I said, and don't say that attempt. Attempt shall be. No, cut that part. Whatever I said, then before that. That is on the view that though an attempt at reconstructing the LCR could be made, it would be difficult to reconstruct the record unless and until copies of the evidence are in the possession of the
parties
or their counsels. So, in this regard, the counsels for the party shall obtain instructions from their client. This is the matter after the vacation. 2010 matter, I think that I don't know what's going to happen.
We will try to get it settled from.
Your clients are still around.
We don't have any contact even.
Then,
24-25%.
okay, just write one more thing. Just Mr. So answer for the respondent.
Workman.
The respondent workman shall also inform this court as to whether he still communicate with his client on the next day.
31.
May it please the lordship. Lordship, this matter relates to settlement of market for the year 18 and 19.
Infructuous.
Infructuous.
Miss
A. Bora.
A. Bora, learned counsel for the petition, submits that as the matter pertains to settlement of the market for the year 2018-19, the matter has become infructuous. Ms. S. Datta appears for the PNRD department, while Mr. S.R. Barua appears for
Number 3.
referee number 3. The writ petition is accordingly dismissed as infructuous.
32 and 33.
Grade 2, grade 3.
Yes. Before he begins, I just want to point out, I given a judgment. If your lordship thinks review lies, your lordship will have to allow the review, put the writ petition in.
Back, correct.
So that is the position of law. That is how your lordship.
Which judgment is that?
Now, judgment one case order in division bench, where while hearing the writ petition, review petition, the writ petition was also disposed of. So against that matter, the writ appeal was filed. Court said when the disposing of the writ petition is not good. Your lordship knows about this. It was not pointed out to the court below, before the learned single judge, that you first consider the review petition. Then thereafter, my lord, if it is review petition is, my lord, your lordship is satisfied, it has to be restored. The writ petition has to be read. Then your lordship will have to hear the writ. So regarding maintainability of the writ petition, review petition, I will just give one judgment.
No, but then you see, those are somewhere, that's a division bench order.
That's a division because my lord, writ petition cannot be heard, my lord, at the time of hearing of the review petition. If your lordship is satisfied with the review petition, your lordship will restore the writ petition.
No, sometimes it can be done also. There's no hard and fast rule. At the time of hearing, but everything else. Because I remember while heading a full bench, we have done that. So that will be a 3 judges bench to do the bill.
But before the single judge, that was the position. I'm just pointing it out. Your lordship is satisfied that review lies.
No, I think maybe, I'm just thinking, maybe it'll have to be considered once again. Because I think his basic case is that they are, this court was under the view of the opinion that the petitioners were grade 3. So he's saying they were grade 2. So we will go only to that aspect, whether they were grade 2 or grade 3. And even if they were grade 2, the judgments in Rafiq Masi also could still apply.
Yes, third only. That's what I was telling my junior colleague, my lord. Maybe the judgment has got a different reasoning. The reasoning could have been different. But at the same time, I've given documents to show that they belong to grade C category.
Grade C.
Grade C. So only nomenclature was changed to grade B. I've shown your lordship. Only the nomenclature was, nothing else. That I have shown before your lordship at page in our affidavit, page 96.
Yes, yes, page 96.
Yes. Only the nomenclature was here, grade B. Otherwise, my lord, one fact your lordship kindly see. I'm just bringing to your lordship's notice. Page repetition.
Consequent upon the notification.
That's a reclassification.
Before the amendment, staff nurse, group C. So then they became group B, non-medical student.
Only reclassification.
Nursing sister was group C, became group B. That was in 2020.
Yes. Otherwise, what was the impugn order? I'm just pointing out, let me speak at thereafter, my lord. In my writ petition, it is page 23, annexure 5 of the writ petition, original.
Page 23.
Writ petition will be there, I think, in file. What was the writ petition for?
Yes.
Impugn order. Your lordship will kindly see. On these cases, how can they go for recovery of the amount?
Page 23.
23. This was the impugn order, dated 21. It is hereby informed to all the existing nursing personnel who joined prior to.
No. Page 23 of the writ petition.
Yes.
To Mazzarello Barla.
No, it is office order. Mr. George, WPC 5225, 2021.
WPC 5225. No, give me that WPC. Oh, there are many WPCs. 5225.
Impugn order is vague. From on that ground itself, my lord, it falls.
5225. There is a lot of writ petitions, lot. Is there in the top? Then there are lots. You see, there are this many writ petitions there. Just a minute, let us get that one at a time.
On this ground itself, this is my submission is on this ground itself. No traffic must be allowed. On this itself, no notice, nothing.
Page 23.
Yes. It is, may I just read yourself?
Yes.
It is hereby informed to all the existing nursing personnel who joined prior to 2016 that the CAG audit has raised objection that pay fixation in respect of nursing personnel has been done erroneously since 2006. The matter is under review, re-examination and refixation of pay by a team constituted by the CA and so office order dated 21. And quantum of excess payment that may be found to have been made as a result of incorrect fixation of pay shall be decided later on for recovery. However, pending finalization of excess payment made, if any, on the basis of refixation of pay as per rule, as well as CAG audit observation, it has been decided. How can they do that? 20,000 will be deducted. On this matter, no Rafiq Masih is also not involved. No notice was given. They have calculated something. They are on the process of calculation. Now they are saying, pending that calculation, 20,000 will be done. So I'm just pointing.
No, that is a different issue. That is,
yes, no.
notice is a different issue.
Yes, notice. No, in some cases, it says, my lord, if there is some excess payment, this was done in the year 2008.
6.
Now, here is, I think, 2006. And yes, 2006 and.
Yes, okay, yes.
My lord, next petition, 4239, 33.
Huh?
Next, 32, my.
Read petition number.
Parla. 4239.
Mazzarello Barla, yes. Page
23, my.
23.
Yes, the notice to the petitioner. By the
Okay.
information regarding.
Okay, anyway, so he says As per your review petition, page 96, there was staff nurse was group C. Nursing sister was group C.
No, my lord, they are group B. My lord,
Come to page 96.
there has to be a promotion order, my lord. For making it, taking us to group B, my lord. There has to be a promotion order. Respondent number one. So this is.
It starts with headquarters through web circulation only. Page Annexure 7, page 96. You don't have it?
My lord.
Give the
there
second
are
copy.
lots
Give
of-
her a second copy. His pleadings are all in bits and pieces, so he's confused.
This is not applicable in our case.
Why?
This is a employee state insurance corporation.
Okay,
The government of
Employee
India,
state-
Ministry of Labor and Employment.
okay, your
It is
ministry of
different society, my lord. We are autonomous body, my lord. We have different, it is not applicable in our case, my lord. They have their own rules, my lord. It is not applicable and my lord, I have given a
Yes, Mr. Das. What have you got to say that?
Yeah, that's what, but in their case, they were in group B, group C. I'll come back to that. I'll come back. It looks like here, state insurance, but it is applied to them also. But I'll come back.
Right.
And the other day, I have given a chart, my lord, pay scale chart. Otherwise, the graphic machine that he will come in. I have given a similar chart, my lord.
Okay, that graphic Masi, supposing since this wrong fixation has been done from the year 2006, then
Then, my lord, undertaking is there, my lord. Okay, my lord, state of Punjab and Haryana High Court and this Punjab and Haryana Jagdeep cases that the employee is bound by the undertaking. It is a mandatory requirement, my lord, to take an undertaking from the at the time of giving a higher pay scale, my lord.
no, but when was the undertaking given?
Revised pay scale.
When was the undertaking given?
Yes, my lord. I have
When?
given undertaking, my lord. I have obtained an undertaking at page.
Mr. Counsel, please listen to the question. You're not answering. When was the undertaking given? When?
2008, my lord.
2008.
39, 2008. It is page 58
58.
in our petition, my lord. And the next page, it is the form of option to.
Why didn't you go in appeal? Why review?
My lord, it was that at the time of hearing of the writ petition, the advocate was not aware about the category of the petitioners, petitioners. And when the order was passed, holding that they are belongs to category C. Category C. And as per in the light of Profigmasi case, this honorable court passed the order. That in the Profigmasi case, C and recovery from employee of C and D, not applicable because of hardship. It caused hardship, but it is the authority can recover from the employee which is categorized as A and B. And High Court of
So the undertaking was given by them in 2008.
2008, my lord. But the language is that the undertaking is, I hereby undertake that any excess payment that may be found to have been made as a result of incorrect fixation of pay or any excess payment detected in the light of this discrepancy noticed subsequently will be refunded by me to the government either by adjustment against future payment due to me or otherwise.
Yes.
The judgment I have given, full bench judgment of the Madhya Pradesh. It has taken into consideration all this. Rockrickma cases are not applicable here also. Paragraph 35. 1.
Yes.
Question 1 is answered by holding that recovery can be affected from the pensionary benefit or from the salary based on the undertaking or the indemnity bond given by the employee before the grant of benefit of pay fixation. The question of hardship of a government servant has to be taken note of in pursuance of the judgment passed by the larger bench of the Honorable Supreme Court in Syed Abdul Qadir. The time period as fixed in the case of Rafiq Masih, report 2015 4 SCC, request to be followed. So that 5 years now. Conversely, an undertaking
What 5 years?
In Rafiq Masih beyond 5 years. Conversely, an undertaking.
No, but the problem is that the pay fixation was done wrongly in the year 2006. Undertaking was given by you in 2008.
2008.
Then
So therefore, my lord, that it is more than, and they are trying to recover from the year 2000 by way of the 21.
from 2006.
2006 by an order dated 21. So it elapsed that 5 years, more than 5 years. And it says conversion is an undertaking given.
No, but you see, the question is, will the validity, does that undertaking have a validity period?
No, that undertaking, my lord, your lordship will kindly see what is the meaning of this under. That Balmar case, your lordship will kindly see. They are the employer.
You're talking about unequal bargaining
Yes.
power.
Yes, and here besides that, my lord, I am saying that because I have given some undertaking in the year 2008, and you are trying to recover from in the year 2021. 21, and Rafiq Masih says if it is more than 5 years, he cannot do it. So Rafiq Masih you cannot ignore. This is what the full bench says. Time period as fixed in the Rafiq Masih reported in so and so request to be followed. It's a full bench judgment of the. It has taken into consideration all the Supreme Court judgments and all. The time period which is mentioned in the Rafiq Masih case, it has to be followed. And time period is 5 years. So therefore, I'm saying, my lord, as your lordship has followed from your lordship, my lord, that reasoning may be different. But Group C, my lord, I speak, my lord, they were not promoted. They were not. They are Group C. They are Group C.
But how do he's saying group?
They are saying so.
You're saying group B because of the pay scale, correct?
Yes, my lord, pay scale.
Because of the pay scale.
On the categories on the basis of pay scale.
Now, in a review, we have to go. Can we go into an elaborate reasoning? A review has to be on the face of the record. It has to hit you straight away. Prima facie it has to be there.
16
Otherwise, if you apply,
it's a good case for appeal for them. For appeal, they could have gone, but not in the guise of review. Para 16 for the purpose of the maintenance of review.
they give me that Rafiq Masih that 5 years.
But that is mentioned in the government paragraph also.
Rafik Masik was also, it was,
You see, I can appreciate the arguments to a certain
appreciated in
extent.
the judgment.
However, whether it can be done in a review petition.
Only the only
Because
wrong
now,
is
you
there.
see, I have got to apply a process of reasoning. But on the other hand, review is basically when there is a mistake or an error apparent on the face of the report. Now, there is nothing apparent on the face of the report. Now, you are trying to take me to a situation or to a issue wherein the pay scale of the various grades of these nursing employees have to be considered.
But
That is not a mistake or error apparent on the face of the record. That is going deep into a subject. So whether in a review, I can go deep into a subject. First of all, I don't like going deep into a subject at this stage after disposing of. But having said that, can I go deep into a subject in a review?
well, only because the review is that, my lord, because like, in my consideration, my lord, because on the day of hearing, if the advocate appearing for the respondent apprised your lordship that they are belongs to
Group B.
Group B, then that order might not have
occurred. But it might have occurred the other way around. When the fixation of pay has been made wrongly in the year 2006, could they have asked for recovery of the said amount 15 years later?
My lord, High Court of Punjab and Haryana
Has held it.
says they are bound by the undertaking, but not. And on the other hand, my lord, in the undertaking itself says subsequently.
Because period is less.
And
maybe, but then the undertaking has no limit, no validity limit. It has
Triple bench judgment.
Supposing I say today that I passed class 10. Can I say after 30 years that I did not pass class 10? Won't they say, the other guy say that in 2024 you said you passed class 10. So what I'm trying to say is, will my statement have a validity period? It cannot. It will be there forever.
In this case, there was a rule. As per the rule, it has been done. But the full bench judgment of the the lordship will look into, and it says the period mentioned in the Rafik Masik case cannot be overlooked. It says so.
Here,
yes.
in this Madhya Pradesh judgment.
Madhya Pradesh
Where?
full bench judgment, paragraph 35. No? Yes. Undertaking given in the year 2006, 21 they say, they have given fixation is bad. And that also they do not say it in details.
But there is provision for suitable installment. Government
On
has
the page 106 of this review petition, that Rafik Masih, those 5 provisions, it is there.
Have the petitioners taken a stand that the undertaking was the first undertaking?
No, the petition
They have not taken.
this did not come in, madam. They did not put it in their affidavit in opposition. Now they are showing, to my knowledge, madam, now they are showing that undertaking is given. We do not know, madam. We will have to.
What to do? You see, it's not big. You cannot say that my earlier predecessor, he said this. It's basically you. It's basically the department. You all have taken the stand earlier that they are Group B. Now you're saying, no. Actually, you are Group C.
because of some mistake, my lord, I can't say, my lord, to my colleagues.
Cannot be a ground for.
Who is fault?
No, the mistake can be a ground for review,
Yes.
but it has to be apparent on the face of the record.
How they say, I don't know how they say they belongs to.
Record.
And there is nothing in your writ petition with regard to their pay scales to show that they are group B.
Because
Is there anything in the writ petition to show that they are group B?
I was not conducted that repetition after the,
No, I'm just asking you now, since you're doing the review, you have got to answer.
but
Is there anything in the writ petition to show that they were group B? The writ petitioners.
my lord, how can?
You see, because now you're taking a stand that they are group B. While we had taken the decision on the basis that they were group C. Now, in your writ petition, did you take a stand they were group B? No. Then now how can it then?
My lord, because
I think you best go to division bench, clear up everything. If it required, it will come down again, they'll decide. How can I go in? How can I go into all these aspects? Pay scale is this, pay scale is that, so they, because of the great pay, because of their, I think basically you're talking about the great pay, correct? Because of the great pay.
Okay.
Because of the great pay of nursing home, they should be seen. But that, those stand is nowhere there in your writ petition. Have you taken that stand?
Let it is still some lack of communication, my lord. This was happened after that. I insisted for those documents from the department, my lord. I got it, and
Then you go in appeal.
as your lordship, please,
I have.
as your lordship, please.
Otherwise, I have to have a lengthy process of reasoning. I have to go through a lengthy process of reasoning to come to
Because the
different.
power lapse, my lord. This will happen.
But then I cannot go into issues, deeply into issues in a review. Though you might be correct, I don't know. You might be correct.
Liberty. I may go to appeal or.
This is that too. You've got all the everything is open to you. Everything is open to you, right?
The paragraph 3 of our affidavit,
Huh?
your lordship will kindly just look into what they have said. These are controversy. Lordship may pass the order. But this paragraph 3 of the affidavit we have stated.
Anyway, heard Mr. A.K. Datta, done at CGC. Also heard Mr. For the review petition. Also heard Mr. B.D. Das, Learned Counsel for the for the
For the
nursing,
respondent,
for the nursing staff,
yes.
for the private respondents. Assisted by Miss Ardeka. Anybody else? Mr. R.K. Talukdar appears for CAG. While you're not there. Well, Miss.
He's also there with us.
Oh, you are there. Yes, yeah. No, CAG is enough. So yes, any submission?
I stated in my, I have no grievance against the case, but only to impede him.
Your grievance is only with me, with the judge, with this order that I passed. What to do? Right. The review petitioner's counsel submits that the impugned judgment and order dated 13/9/2022 passed in WPC number 258/2022 and the seven other writ petitions, and the other seven other writ petitions should be reviewed, in as much as this court had allowed the writ petitions by holding that there could not be recovery of any excess payment made to the writ petitioners, as they were holding COs in terms of the judgment of the Supreme Court in the case of State of Punjab and others versus Rafiq Masi bracket whitewasher, 2015 4 SCC 634. Next para. The review petition counsel submit that when going into the pay scale enjoyed by the writ petitioners and the grade pay being given to them, it is clear that the writ petitioners were holding group B posts and not group C posts. He also submits that while there had been wrong fixation of pay of the writ petitioners as far back as 1/1/2006, the writ petitioners had executed undertakings that they would give back the excess pay given to them. And executed undertakings in the year 2008. They'll give back excess pay given to them due to wrong fixation of pay. He submits that the recovery of the wrong fixation of pay of the petitioners started in the year 2021.
During audit report is what came to light, my lord.
When did it start? Please answer the question.
2021.
Huh?
2021.
It started in 2021. And as the undertaking given by the writ petitioners was still valid, there was no infirmity in the recovery of the excess pay given to the petitioners, even after 15 years. Not say given back, you say refunded, huh? Refund. Next para. The learned counsel for the review petitioners further submits that in terms of the judgment of the Supreme Court in the case of High Court of Punjab and Haryana versus Jagdev Singh, 2016 14 SCC 267, an officer who has furnished an undertaking, don't say an officer, an employee who has furnished an undertaking that excess payment made to him would be refunded, was bound by the undertaking so given. Correct?
Yes, my.
That's all. That's your case. Anything else? No. Next. Mr. BD Das. No, say that. He accordingly submits that the impugned judgment and order passed in WPC number 258/2022 and the other writ petitions should be set aside and the review petition should be allowed. By allowing the review petition, first off, Mr. BD Das, Leonard, senior counsel for the private respondents, for the writ petitioners, on the other hand, submits that there is no mistake or error apparent on the face of the record. And as such, when a lengthy process of reasoning is required to be undertaken, a review petition will not be maintained. He also submits that there is nothing in the writ petition. There is nothing in the there is no stand taken by the review petitioners at the time of disposal of the writ petitions that the pay scale of the pay scale enjoyed by the pay scale and grade pay enjoyed by the writ petitioners showed that they belong to Group C post. No, they belong to Group B post, Group B post. Full stop. He also submits that in terms of the judgment of the Supreme Court in the case of Rafiq Masi Supra, comma, when there has been wrong fixation of pay for more than 5 years, comma, the question of recovery of the wrong fixation of pay does not arise, comma, especially when there is no fraud or misrepresentation made on the part of the writ petition. He also submits that in terms of the full bench judgment of the Madhya Pradesh High Court, is it? In the case of Madhya Pradesh High Court, in the case of State of Madhya Pradesh through Principal Secretary and others versus Jagdish Prasad Dubey, 2024 SCC online MP 1567. What do you want to show? What do you want to say here?
Writ appeal number 815/2017.
Huh?
Para 35.
Fair 35. Submit that. Oh no, what have I said? So, comma, even if
First question.
ah, no, yeah. Don't say even if. Recovery can be effected from the pensionary benefits or from the salary based on the undertaking or the indemnity bond given by the employee before the grant of benefit of pay refixation. However, the time period as fixed by the Supreme Court in Rafiq Masi Supra was required to be followed. Full stop. As the recovery of the excess pay has been made 15 years after the wrong fixation of pay had been made. Comma. No recovery could have been made in terms of the decision of Rafiq Mashi Supra. Correct?
Yes.
Anything else?
Yes. That impugn order itself shows they have not refixed. There is no calculation of what wrong.
Which way the impugn order?
The page 46 of the writ petition.
46 of the writ petition. Which
of the writ petition?
Huh?
5225/21.
Para 20, page 23.
Yes.
Page 23.
That was my.
Next paragraph. He also submits
Yes.
that in terms of the office order number LGB/ESTT/audit/1948/18/2230 dated, is it correct?
Yes.
Dated 25/6/2021, issued by the administrative officer, LGB Regional Institute of Mental Health, Government of India, Ministry of Health and Family Welfare,
Matter is under review.
There is nothing to show that there was any wrong fixation of pay of the petitioners made in the year 2006, especially when they have not clarified as to what should have been the correct fixation of pay. at that period and even as on date. Correct? Anything else? Where is the Rafik Mashi case?
That your lordship will get it at page, petition part 106, I think.
106 of the review.
Yes. That 5 paragraphs, no? They have issued a memorandum. Your lordship will get it at page 105.
Yes.
Office memorandum, Government of India, dated 2nd March 2016. And paragraph 4, your lordship will get the drafts of the Rafik Mashi case.
Okay, right. I have heard the net counsel for the parties. In the case of Sanjay Kumar Agarwal versus State Tax Officer, bracket 1 and another, reported in 2024, 2 SCC 362. The Supreme Court had considered various decisions, various other decisions of the Supreme Court, and held that the gist of the various decisions of the Supreme Court, as mentioned in the said case, in para 16.1 to para 16.8 were as follows. Okay, okay. Good stuff. Next para. In the present case, there is nothing to show that there has been a mistake. No, before that. Next, in the case of Rafik Masi Supra, the Supreme Court has the Supreme Court has held that it would not be possible to postulate all situations of hardship which would govern employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement. It, however, held that recoveries by the employers would be impermissible in law in the following circumstances. Page 106, 1 to 5. Next part. This is in the review petition. Okay. Next part. In the present case, the present case appears to have been covered by clause 3, as the excess payment has been made to the writ petitioner from the year 2006, and recovery has been made, had been initiated only from the year 2021. That is after 15 years. Next, without going into the other issues raised by without going into various other issues, the fact remains that the counsel for the fact remains that the impugned order, judgment order dated 30/9/22, had been made on the concession given by the review petitioner's counsel therein that the writ petitioners belong to Group C post. Full stop. In the present case, in the present review petition, an diametrically opposite stand has been taken. That the writ petitioners do not belong to Group C post, but to Group B post, on the basis of the pay scale and grade pay being given to them. However, the said stand was never an issue taken by the review petitioners in their at the time of disposal of the writ petition. The manner in which the review petitioners council is trying to review the impugned judgment and order is not self-evident in the impugned judgment and order. The same requires to be detected by a lengthy process of reasoning, which cannot be done in a review petition. In as much as a judgment is open to review if there is a mistake or error apparent on the face of the record. In the present case, there is nothing apparent on the face of the record. And as held by the Supreme Court, yes. In the case of State of West Bengal versus Kamal Sen Gupta, 2008, 8 SCC 612. Review cannot partake the character of an appeal. In view of the review state above, this court is of the view that no case for review of the impugned judgment and order has been made up. The review petition accordingly dismissed.
Really question maybe was on.
You have got the right. You've got the right to challenge the single bench judgment. The only thing is that you cannot challenge the review order. That is barred.
Yes.
You can challenge the original order.
Original order, that is why.
That is the best. You go there if they said that, because I have to do a lot of reasoning. I have to go through all your pay scales, all your grade pays, and then to find out whether really Group B or Group C. The connected with petition also you put it here on. Instead of Miss, you put Mr. S.C. Biswas, I think. Okay, let her be there. You also put Mr. S.C. Biswas name for the private respondent. S.C. Biswas. Huh?
That petition may be segregated because several petition is pending till now.
Which is quoted first or
Huh?
now follow the same fate. It's not
Same.
Same fate.
Same,
It is the same issue,
same issue.
same nursing thing.
Now he's here, he's all right.
Huh?
Now he's here, he's all right. Because of your lordship's suggestion, he got it corrected. You should not miss
He's,
something.
he's got different tactics, huh?
No, your lordship suggested, corrected, he corrected.
Different folks, different stroke for different folks.
Because of.
And- Huh? What writ petition? There's a writ petition.
Yes.
Okay, it's a writ petition.
Writ petition is-
That's a review petition, no?
No.
No, writ.
Writ petition.
No, writ I'll have to, writ no, we won't dispose of writ then. Writ some other day. Take it. Writ because it will be slightly different, so it cannot be here.
It will follow the same judgment by not by your.
That is there, that is there, that is there, but let us leave it at that because out here, he's going to take all these time. This is required. Huh? No, this is required, this is required, and this is required. We don't want this. What is this? DY temperature. Jagdish, this is required. This is required.
After vacation. 33 will be after vacation.
33.
This,
Yes, 33 after vacation. At 33, right? On the pair of the counsel for the parties. No, who is there? You're not there.
I'm not, I'm here.
You're not there also. Okay, you're there. On the pair of Mr. S.C. Biswas and Mr. A.K. Datta, CGC, leave the matter after the vacation. Okay, we stay in the meantime. Heard Mr. Jay Barbuya, learned counsel for the petition, huh?
Arthur.
Arthur, learned counsel for the petitioner who submits that the petitioner had participated in the NIT dated 6/6/2024 settlement of the huh?
Athiabari bi-weekly market.
Athiabari bi-weekly market. Full stop. Though the petitioner's bid amount had been approved by the
Market settlement committee.
by the market settlement committee as his bid amount was the highest, the respondents have approved settlement of the said market with the respondent number 6, whose bid amount was less than the petitioner's bid amount. Next will be taken in the matter by the BTC within a week. So, next para. On considering the fact that the petitioner's bid amount is the highest, and as no reasons have been given for approval of the bid amount of the respondent number 6, which is less than the bid amount of the petitioner, the no settlement order, correct? No settlement order should be issued by the respondent authorities in favor of the respondent number 6 till the next day.
If already.
If not already issued. First off, in the event the settlement order is issued, it is directed that the respondent number 6 shall not operate the said market till the next day. This is the matter on. Okay, before that, issue notice. Issue notice returnable in a week. Ms. R.B. Bora accepts notice on behalf of
One to five.
respondents number
1 to 5.
1 to 5, petitioner takes steps for service of notice upon the respondent number 6 by registered post with AD within the course of the day. Full stop. In addition to the above, the petitioner shall also serve notice upon the respondent number 6 through dusty service within 5 days. This is the matter.
Lordship, in this matter, we will also file an affidavit, Your Lordship. It will be taken after vacation, we will file an affidavit, Your Lordship.
Why after vacation? You've already, huh? Why?
So we have received the paravise.
So you have already received instructions?
Yes, but we
That
are
was in
looking
August.
for the up-to-date instruction, Lordship. Whether steps have been taken for and the steps taken for initiating the payment of the respondent, Lordship.
But
Because as per my
Huh? Yeah.
last occasion, my lord,
Correct. You have taken time, Mr. Counsel. What is this?
So last time we'll file. I'm waiting for updated instruction whether.
We don't want this. He doesn't want instructions. He doesn't want your affidavit.
he
He
wants-
just wants compliance. That's all.
That's all, Your Lord. That's
Then-
why, Your Lordship, whether any steps have been taken for initiating the payment.
If you cannot obtain instructions, we'll direct them to appear.
Small
Not
amount,
difficult.
Sure, Lordship.
small amount, my lord.
Small
Small
amount.
amount. And part payment has already been made, my lord.
You get your instructions. You've already received instructions.
Yes, sir.
You submit your affidavit within a week. Otherwise, I'm going to call them. They'll have to appear. Mr. R. Goy, the counsel for the respondent number 2, in all the 3 contempt petitions, is granted one last chance to file affidavit on behalf of the respondent number 2, inasmuch as instructions had been received by letter dated 14/6/2024, issued by the chief engineer (PHE, sanitation, Assam, in terms of the order dated 31/8/2024 passed by this court. Leaves the matter on. You are it.
All right.
Yes.
Let me, Your Lord. Although the petition looks voluminous, issue is very small one. And with greatest respect, normally hate to use such strong word. They literally, virtually misled Your Lordship into passing the order.
Okay.
And the basic facts were also not brought to Your Lordship's notice. And Your Lordship will recall the judgment. It pertains to the tender. I am not troubling Your Lordship with the judgment itself. But the facts are like this. Your Lordship will straight away come to their main argument was, since the earnest money, security deposit was refunded, it can be presumed that he could not have been disqualified on account of making misrepresenting.
But that was not the reason for the order.
But that was the thrust. The basic document was not even placed before Your Lordship. Your Lordship will first come to the clause itself. Your Lordship will find page 133. What has happened? If Your Lordship will kindly come to page 133.
Their only case was that whether the documents were fraudulent or not.
That was not the reason why he was disqualified. He was disqualified because he did not meet the experience criteria. In spite of the documents being there, he does not meet the experience criteria. So what they did was, the reason why it was refunded is this one. Page 133, Your Lordship will kindly come.
Yes.
Clause 9.
Yes.
Refund of earnest money. The earnest money of the tenderer shall be refunded as per Finance Department, Government of Assam, OM number so-and-so dated 21/8/2019. If Your Lordship will, that OM itself was never placed before Your Lordship. That OM Your Lordship will find at page 32. This is the OM. And if Your Lordship kindly turns to page 33.
Yes.
At the bottom of the page, this is a circular in respect of refund of money and etc. Various aspects. Now, with regard to refund, what it says is this. Right at the bottom, Your Lordship will find.
Yes, yes.
Refund settlement process. E-procurement portal of Government of Assam has 5 stages for 2 cover system. After bid submission, closing, technical opening, technical evaluation, financial opening, financial evaluation, and award of contract. After completion of every stage, tender inviting authority will declare the status of every participated bidder as successful or unsuccessful. Every unsuccessful bidder will get back his or her EMD within T+4 bank working days, where T will mean the date on which the information on rejection of the bid is uploaded in the e-procurement portal by the TIL. So as soon as it is rejected, that day is considered to be T plus 4 days. It is a mandate of this circular that if a person is declared as unsuccessful, his earnest money will be refunded. That forfeiture clause comes into play only when falsehood is taken into account. Now, his documents that he had submitted, if your lordship will first come to the qualifying criteria at page 147.
Yes.
Page 147. At the very top, similar work experience.
Yes.
There are two preconditions. The bidder should have completed next in his own name. So he has to complete the work as a prime contractor, not as a subcontractor. And therefore, he did not meet any of these criteria, and it is an.
But then what about all proportionate share as a member of a joint venture?
He is not a joint venture. So therefore, assuming everything on face value, he does not meet the criteria because he completed the work as a subcontractor. And the subcontractor, who is the authority who is giving, some UP Nigam Limited, who actually constructed the Meghalaya Assembly Building. He had subcontracted some work. How would a Assam PWD, how can it even verify? Because the contractor may give any kind of certificate to anyone. That is why the mandate always is in these PWD contracts across.
In his own name.
It has to be as a prime contract. So by his own showing, he was a subcontractor. So these aspects were not even brought to your lordship's notice. And what happened, perhaps what happened was, since your lordship took it up at the motion stage, notice was not even issued to me. And I was in the meantime declared as an L1 bidder, which was not even brought to your lordship's notice.
Because this financial bid was not open. No?
It was open, my lord. That document, if your lordship will kindly come.
No, wait. What was the order? In the order, what did this court say? That the financial bid was opened or not? Anything to that
That is not well, factually not even
recorded. So you're L1, but you have not been selected as yet.
No, I was declared as the L1. Page 55 will show that.
55 of?
Page 55 of this review petition. I was declared as the L1 on page. This was on 5/8/2024 itself.
Page 55?
Page 50.
No, this
Much
is
prior to.
No, this is okay. BQ1, BOQ1. This is BOQ1. NHJ.
This is the declaration in the website about the financial bids of the success people.
Your Tribeni construction.
Yes, and I was the respondent number 4. And since notice was not even issued to me, I did not have an opportunity to even place all these facts. Therefore, this is a out and out case for.
So has the contract been awarded, not awarded?
It would have been awarded, but
for the order.
And
one order has been passed now, which is under challenge. It came up on Wednesday.
Even now, once again, after reconsideration, your lordship remanded it back for reconsideration. The tender committee apparently sat again, examined the whole thing, and since he does not meet the eligibility criteria, he has been rejected again. And now taking advantage of this order passed by your lordship, they have filed another writ petition. So therefore, my lord, if your lordship stays this review order path in the review, then everything will get automatically.
I cannot say it straight. I have to ask. Both
the matter may come together on Wednesday.
Let both the matters come up together on Wednesday.
WBC 478.
Just a minute. Heard Mr. I. Chaudhary, Learned Senior Counsel for the review petitioner, assisted by Mr. T. who submits that the impugned judgment and order dated, impugned order dated 29/8/2024, passed in WPC 4034/2024 should be reviewed. Inasmuch as the writ petitioner did not have the work experience as required under clause 2(a) of the NIT, wherein it states that the bidder should have completed in his own name. That in his own name, you make it bold, huh? In his own name. The conditions provided therein.
And my second main ground is that the order could not have been passed without issuing notice to.
Further, the impugned order could not have been passed without issuing any notice to the review petitioner who was the respondent number four in the writ petition.
Since he was already declared as the L1 bidder.
Inasmuch as he had already been declared as the L1 bidder on
5/8/2020.
5/8/2024. Bracket page 55 of the page.
Two, three, and four.
2, 3, and 4. While Mr. S.R. Barua appears for respondent number 1.
Oh, one has to be by government advocate. Sorry, respondent number 2 has to be by government advocate. 3 and 4 my friend.
You'll be 2 and 3 only, I think.
But I will be, no, he will be 2. Yes.
No, you will be, huh?
3, 4 I am appearing.
Okay.
Chief Secretary is appearing.
No, Badri Rai, okay. Mr. S.R. Barua for 1.
No,
Well,
No, Lordship may see page number 2.
Page number 2.
Page number 2. Badri Rai is number 1. That is notice will have to go.
Notice will have
So
to.
2 will have, 2 is the state of Assam.
2 is.
Two Chief Secretary.
That's what I'm saying.
Yes.
Mr. S.R. Barua accepts notice on behalf of respondent number 2. While Mr. B. Gogoi accepts notice on behalf of respondent number 3 and 4. Fine. Bracket PWD. Petitioner takes steps for service of notice upon the respondent number 1. Respondent number 1 / writ petitioner. Within the course of the day. Further, in addition to the above, the petitioner shall also serve notice upon the respondent number 1 / writ petitioner through dusty service. List the matter along with WPC number
4789 of 24.
4789 of 24 on Wednesday.
I am taking 98 to 40.
All right.
Lorships. In this matter, we are against the remission part, your lordship. Otherwise, the settlement period is over.
Then what
But
do
we
you
are
mean?
against, we are on the remission part, your lordship. 17 to 18, we could not operate because there was ban on fishing and turbidity and all. So because of which we could not operate. So we have.
Where is Mr. P. Sharma? Okay.
Yeah, they are looking after.
The new.
Yes.
So he says that she's asking for remission of the installment payable for the period from
2017 to 18. If your lordships may come to
2000
page number 18, your lordships is the prayer part. First prayer is, your lordships, why written the nature of mandamus should not be issued directing the respondent authorities to remit the remaining amount of lease value for the year 2017 to 18.
Yes. So what is your stand?
Lordship may kindly come to page 80 of the writ petition.
18.
80.
Yeah, 80.
Although they have made representation before the Fishery Department government, but whether it was received or not else cannot be ascertained, lordship. Because the emission part is dealt by the government only.
This is a risk, madam, you take.
Lordship?
This is a risk that you take, whether there's fish or not. You have been fishing there since 2014.
Yes, your lordship. Lordships, I would pray that we have filed representation also regarding the remission part, but they have not acted till now.
So far as the factual part is concerned, lordship, that circle officer has filed his affidavit by respondent number 6. They are alleging that the
Yes.
yes, they are saying that some pollution of the water of the Brahmaputra, that river, lordship,
But no such record. Lordship may kindly come to paragraph 10 of our affidavit.
Yes.
Yes, may I read, Lordship?
Yes.
With regard to the statement made in paragraph 10 of the writ petition, the deponent begs to state that the report of the circle officer, Nagarveda Revenue Circle, dated White so states that no communication has so far been received from any government agency, including Pollution Control Board, Assam, or there is no record to show that any complaint from the petitioner was received, or there is so far no documentary evidence which is in the knowledge of the circle office regarding abnormalities of the river Brahmaputra. Therefore, the question on the severe pollution of the body leading to death of various kind of fishes as stated by the petitioner totally baseless. The petitioner could have approached the Pollution Control Board Assam and also to the Fishery Department, Government of Assam for verification of the same. Only Lordship that news, they have annexed the publication of some news article. This is not the way, Lordship.
Anyway, whether there was, you did not catch fish or not, how are they, why should they act? It depends upon if their discretion. You have agreed to that 7-year period. You have given your tender amount. How do every business has the risk of either making a loss or making a profit?
Lordship is just on the remission part, your lordship. Otherwise, I'm not on the settlement.
No, that's correct.
Settlement period
That,
is
no,
otherwise over.
no. So what do you want? So what do you want now? Can't they take a decision which is not to your liking? Do they have the right to take a decision when, or they have to make a decision in your favor?
Lordship, I'll file a reply in that case, your lordship.
No, you tell me. Because you see, you had 5 years to file a reply.
Lordship, this matter has come after a long time. May give a week's time.
Okay, Miss
Ashram.
S. Sharma appearing for the petitioner is granted a week's time to file a reply. So the case of the petitioner here is that the settlement period of the fishery has expired. However, the prayer of the petitioner is that there should be a remission of the revenue payable for the year 2017-18. In terms of Rule 16 of the Assam Fishery Rules 1950. So what have I said earlier? What have I said earlier part? Yes. Okay, then you write Mr. S.R. Barua appears for the respondent. List the matter after the week. Give a date.
Deeply.
1349 for hearing.
Right. Matter relates to non-payment of contractual bill. Here,
How much?
1 crore 81 lakhs,
1 crore 81.
81 lakhs.
That's all.
And the facts behind filing of this petition charge. There's point number 2.
No, so there is the admitted amount.
No, my lord, this is between two parties, private parties. Actually, REIT is not maintainable as such, my lord.
Two private parties.
Yes, submitting to that, I think.
No, just a minute. So you're the what? You're the subcontractor.
Yes, my lord.
You're the subcontractor.
But restaurant number 2 has allotted the work to the restaurant number 4. Restaurant number 4 has entrusted me to carry out the work.
The entire work.
I have carried out the work.
The entire work.
Madam.
The entire work or part of the work?
Part of the work.
Part of the work.
Then madam, the restaurant number 2 has terminated the work of the restaurant number 4, madam. Whatever the work I have done, my lord, I have delivered it to the my respondent number 2, my lord.
You go to civil court.
Yes,
for the-
that's true, my lord. It was my height. However, my lord,
Is there
section
any, is there any arbitration clause? in
No,
the
no.
agreement?
So far, the contract in between the respondent number 2 and 5 with me, it is admitted that there is no contract. But so far, section 70 of Contract Act is, Contract Act is concerned, my lord. It is applicable to us. So far, we have, my lord, carried out the work. The benefit has been taken by the respondent number 2 and 5. I have done the work through respondent number 4, my lord. And the respondent number 2 and 5, after getting the benefit of my work, completed work, they have taken the bills from BCPL matter. Now, so for the rule of the section 70, in relation to our case is concerned, they are also liable to pay the amount to us. The very the defense raised by the respondent number 2 and 5 is such, there is no privity of contract in between the petitioner and the respondent number 2 and 4. And so far that part is
No,
concerned.
who has awarded you the contract, subcontract?
Respondent number 4, NAPS.
My lord, just 1 minute.
My lord, the director of
My
NAPS.
lord, my lord, the original work belongs to organization called Brahmaputra Cracker and Polymer Limited.
That is respondent number?
That is respondent number 3.
Okay, then?
Respondent number 3 has given part of the work. That is that cracker, it is in Dibrugarh. And for development and construction of that project, respondent number 3 has given part of the work to respondent number 2 and 5. 2 and 5 is the same party, Engineering Projects India Limited.
Then?
And Engineering Projects India Limited has given some work to NEPS. NEPS is respondent number 4. And respondent number 4 has given part of the work to the petitioner. So, my lord, any of the government companies do not have any privity with the petitioner.
Who is the government company here? 3?
My lord, the Brahmaputra Cracker and Polymer Limited, that is BCPL, respondent number 3.
And 2 and 5.
And 2 and 5. Public sector undertakings. And there is admission also, my lord. I can point out that in the petition itself, my lord.
So far, my case is concerned. Yes, my brother has submitted the facts. I'm not denying that there is a contract in between the respondent number 2 or 5 or 3 with me. I'm admitting that there is no direct contract with that particular respondent. I have contract with the respondent number 4. Restaurant number 4 has.
This is a private contract, Mr. Counsel, between two
yes,
private parties. You
yes.
go to civil court. What is the question here?
I did. But so far, for clearing such a point regarding rule of the section 70 of the contract, whether I am entitled to the. So for the section 70, in respect of our case is concerned, whether it has some role.
I don't know. I've got no idea.
I am reading that part. Even my lord, I am I have no contract. Within contract with the respondent 2 or 5, but I have carried out some work for them.
Maybe, but then that you were not supposed to do it. 4 was supposed to do it.
For that purpose, my lord.
They have 2 and 5 don't know unless you show that 2 and 5 was also part of the agreement.
Yes, but section 70, if you would also permit me to read my.
Yes.
Obligation of person enjoying benefit of
Indian Contract Act.
In
17 fraud.
No, 70, my lord.
Oh.
Sorry.
Yeah.
Obligation of person enjoying benefit of non-gratuitous act. Where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the things so done or delivered. In relation to this part, madam,
This is basically a money suit.
Yes.
Then how is it a writ petition? How can you come?
And so for the
Any citations in your favor?
section 70 is also applicable to government, but so far that bifided judgment, I have not found that. Bifided. I have to search to that effect, but
No, there's nothing.
yeah. So far, my lord, since the
Give me some certificate.
Yes, my lord. You were against my lord.
Para 11.
Yes, my lord. May I read, my lord?
Yes.
A statute may expressly or impliedly confer power on a statutory body to enter into contract in order to enable it to discharge its function. Dispute arising out of the terms of such contracts or alleged breaches have to be settled by the ordinary principle of law of contract. The fact that one of the parties to the agreement is a statutory or public body, even if we had relationship with them, public body will not by itself affect the principles to be applied. The dispute about the meaning of a covenant in a contract or its enforceability have to be determined according to the usual principles of the Contract Act. Every act of a statutory body need not necessarily involve an exercise of statutory power. Statutory body, like private parties, have power to contract or deal with property. Such activity may not raise any issue of public law. In the present case, it has not been shown how the contract is statutory. The contract between the party is in the realm of private law. It is not a statutory contract. The dispute relating to interpretation of the terms and conditions of such a contract could not have been agitated in a petition under Article 226 of the Constitution of India. That is a matter for adjudication by a civil court or in arbitration if provided for in the contract. Whether any amount is due, and if so, how much, and refusal of the appellant to pay it is justified or not, are not the matters which could have been agitated and decided in a writ petition. Contractors should have relegated to other remedies. My lord, the second one. Second one, my lord, paragraph 22. My lord, it is in internal page 126 of the judgment. May I read, my lord?
Yes, yes.
There is a line of the decisions where the contract entered into between the state and the person aggrieved is non-statutory and purely contractual, and the rights are governed only by terms of the contract. No writ order can be issued under Article 226 of the Constitution of India so as to compel the authorities to remedy a breach of contract, pure and simple. My lord, if we had contract with the petitioner, then also they need to go for money suit.
Anyway, what is there? There's nothing, Mr. Counsel. You go to the civil court.
that liberty may be given.
Liberty is always there. There's no requirement.
So far, my lord, because 2012, my lord.
No, it doesn't matter. What you can do is you can apply section 14 of the Limitation Act.
But so far, my lord, that may not be, my lord, written in the plain because my lord, so for the limitation part is concerned, section 14 of the Limitation Act is concerned. It is, my lord, in respect of suit, my lord, appeal. Or approaching a wrong from. If the such observation is given, my lord, that will help the petitioner. Otherwise, my lord, he has completed.
I don't know if I can give, just give me the Limitation Act.
Exclusion of time of proceeding bona fide in court without jurisdiction. That is correct. Yeah.
But this is already there. Why should I mention? Why should I mention? You take records.
Slight observation may be given. Otherwise, my lord, for his my lord, you will get nothing if the suit was dismissed.
No, we are.
Absence of my lord, lordship, my lord.
You see, Mr. Counsel,
Yes.
please, have you read section 14?
My lord.
If you have read, then what do you want? We cannot spoon feed you everything. Right. Mr.
MK Sharma.
MK Sharma, learned counsel for the petitioners, a petition. And Mr.
P Goswami for respondent number 2 and 5.
P Goswami for respondents number 2 and 5. The petitioner's case. No, anyway, why is who is for the respondent number 4?
Respondent number 4.
Yes, Chakraborty was appearing.
Papia Chakraborty.
Who?
Papia Chakraborty. P Chakraborty.
Where is he?
She.
Where is she?
She's not attending for once or twice. He's not representing.
On the other hand, you see, the problem is that why should we send the petitioner all the time to another? I understand the law, but then other things been
Respondent number 4 has become. That, my lord, I don't have any idea because there was the order was of such nature. Even BCPL was also directed not to give us payment, but to deposit the entire money in the account of Punjab National Bank. So we contested that at DRAT.
Loan was taken by respondent number 4.
Respondent number 4. We contested that order at DRAT. So we have received the money from BCPL, but we are not able to give it in the account of Punjab National Bank also.
How much is due to you?
My lord.
How much is due to you?
1,81 lakhs, but the respondent has certified 19 lakhs, which is I have mentioned in my additional liability. I am satisfied if the 19 lakhs is paid to me. I will be satisfied.
My lord, that figure is also popping up from various. That is, we have to whatever is due. We can.
What is due to the respondent number 4?
Respondent number 4 payable. I do not know at this stage, my lord. But 5.86 crore.
Respondent number 4, you have got to pay respondent number 4, 5.86.
Yes, that we cannot pay to Punjab National Bank because this writ petition has a stay order, my lord.
We will ask you to deposit that 91 lakhs here.
But
then with
that
the other,
they have to set aside the order of DRT. Otherwise,
who will have to set aside?
I am not the part.
The respondent number 4. Otherwise, it would be overlapping of order.
No. Overlapping of jurisdiction.
Yes, my lord. Because how can we, once DRT has said, we have no problem, 91 lakhs giving it in the High Court registry. But that has to we have to be considered that order.
But then at the same time, DRT had to consider that this case was here also.
Yes, my lord.
As I have put.
They can be a party to DRT. That we have the certificate, they have received certificate from respondent number 4 that it is 90 lakhs.
You have not deposited that 5 so
No,
crores.
my lord, how can we, because this order of 6/2014 of this writ petition itself bars us.
It was passed prior to the DRT job.
Yes, that is why we are not doing anything. We are
So this order
just
will
keeping
prevail.
deposits. It is in our hands only. Once this gets disposed of, my lord, then we can deposit at DRT. And if something extra remains, then they can take it by way of civil court, and we don't know whether respondent number 4 wants to give it or not to them.
Where is the admission by the respondent number 4 that he owes you this much?
Affidavit has been filed.
Yes.
I have filed one additional affidavit, madam.
My lord, there is a IA 1695 of 2020.
Give me 1695.
Annexer B, my lord. It should be page 9.
So since 2019, you've got no pay?
No.
Nothing. So page 9 they've admitted to 90 lakhs.
They have admitted, but my lord, I have also filed a reply to this affidavit. There is disputed question of fact, my lord, because in my affidavit, they have also forwarded a forwarding letter. My lord, my affidavit is dated 26/3/2019 in this writ petition.
Huh?
Affidavit, my reply to additional affidavit.
Reply to additional affidavit?
Yes,
You mean reply to this application?
yes, my lord, it is affidavit in opposition against additional affidavit dated 19/2/2019.
Page paragraph 6.
My lord, this forwarding letter,
Page 8. Just a minute. Yeah. MS NEFS India is the respondent number 4.
yes.
Unless, my lord, the respondent number 4 certifies, my lord, my work is not accepted by the respondent number 2 and 5.
So 90 lakhs has been accepted by them. So who are you to dispute that?
My lord, they have said that against our final bill of 1,31,60.
Correct. So he's happy with
Yes,
90,000.
madam.
That's what he said.
That is certified, madam.
My lord, how in this writ petition we can decide everything, my lord?
No, we're not deciding.
It is not a admitted liability also, my lord.
No. Like you said, who are you to question the contract agreement between the 4 and petitioner?
Yes, my lord.
You see, the thing is that this is a contract between 4 and the petitioner.
Yes, my lord.
And now he has made a bill for 1,31 lakh.
Yes, my lord.
Same has not been accepted by the respondent number 4.
Yes.
Respondent number 4 says that he is liable to get 90 lakhs.
Yes.
Now petitioner is happy with that. Now you are supposed to pay the respondent number 4 5 point something crore. You can't get 90 lakh from there.
And deposit that 90 lakhs too?
They will get
They deposit it here. in the registry of this court. Otherwise, what will happen? Now,
Well,
they
that
are
can
now.
be done, but that would tantamount to taking the rights of Punjab National Bank, because Punjab National Bank, I don't know about the dues of Punjab National Bank. We would be shrinking the demands of Punjab National Bank.
Maybe at the same time you're taking away the rights of the petitioner also.
My lord, I am not taking, my lord.
Then
It is respondent number 4.
correct.
My lord, we may be allowed to deposit whatever it is in Punjab National Bank.
No.
So Punjab National Bank will decide what is the amount.
Why should we then? Why don't we submit the entire case file to them? Let them decide this entire case.
My lord, what I say, my lord, as per
How
my.
can? Why should we allow Punjab National Bank to be High Court? The writ petition is before this court, not before Punjab National Bank. You want to bow your head before them, you go do that. That is your problem.
I'm just telling that this case as a whole between
It is very complicated, no doubt, because probably he's taken a loan. We don't know how much loan has been taken.
Yes, my lord.
The problem is the respondent number 4 is not here.
Respondent number 4 is not here. Certification is there under his hand. Respondent 4 certification we cannot submit that.
No, because we also want to know how much is due to PNB also, how much loan he has taken.
Yes.
Because the fact is that if he has taken a loan prior to the agreement with you, then they've got the first right to everything.
Yes.
So for the loan part is concerned, it is in the respondent number 4 and 5, forced liability towards the bank. Respondent number 4's liability towards the bank. That is why bank has demanding the money which the respondent number 4 has taken from the bank.
Correct.
But so far my part is concerned, I have carried out the contract, my lord. That is not related to the loan taken by the respondent number 4 from the bank. My investment is there, madam. I have not taken loan from Punjab National Bank, nor I am jointly applied.
No, the same way.
Madam.
Respondent number 4 has taken money from the bank.
But respondent number 4 has taken money from the bank. The any liability to be paid to the bank by the respondent number 4, madam. From the my.
Why are you not, you release the money here, that 90 lakh?
But respondent 4 will not suffer
The
any
registry of
loss,
this
madam.
court.
2 and 5 shall not suffer any loss if the petitioner.
You see, it's very easy for this court to send them to the civil court. But the fact remains is that we are supposed to redress their grievance.
My lord, is correct. But my lord, even disputed question of fact also can.
Where is the disputed question of fact?
My lord, what is the amount to be given? We don't know that the work done by them has also to be measured, my lord. Or I don't know, my lord, it is how everything is to be done.
You
my lord,
see,
here.
whatever has to be paid to the thing, work has to be measured.
Yes, my lord.
So far, that
Respondent.
Where is the measurement of work?
that is not my question, madam, as on today. Now, madam, it is question. So far, my work is concerned, there is no question.
They have made a bill of 5.06
No
crores.
dispute has been.
No, but then who are you to question?
Why, my lord, it is from my side only the money would go. I would have to measure the work, my lord.
Then you measure the work. Because on the one hand, you are saying you have got no privity of contract with them. But now at the same time, you are saying, unless you measure the work, you cannot pay. Huh? Correct. So whatever work he has done amounts to work being done by the respondent number 4. When the respondent number 4 has admitted of 90 lakhs, you measure that 90 lakhs as if it's done by the respondent number 4. Don't think of it as work done by respondent number 2, by the petitioner. You think of it as work done by the respondent number 4. That's all. What remains? Where is the bill for your 1 crore something?
From my page 45 to 123 are the bills.
Page 45 to
123, madam. 3 bills were submitted.
Okay, wait. What have I said? Please read. Okay, right. The petitioner's case is that he had been given a part of the contract work for construction of plant building -1 in the Assam gas cracker project being executed by the respondent number 2, Government of India undertaking. He submits that the part of the construction part of the construction work being given to the petitioner had been made by the respondent number 4. Though the petitioner had submitted a bill amount of rupees 1,31,64,061.85. Page 202 it is there. The respondent number 4 has admitted the bill of the petitioner to the amount of rupees 90 lakhs. The petitioner's counsel submits that the said 90 lakhs should be released to the petitioner. Next paragraph. The facts of the case is that the contract work had been given to the respondent number 3 by
2 and 5.
had been given to the respondent number 2 and 5 by the respondent number 3. The respondent number 2 and 5 had thereafter given a part of the contract work to the respondent number 4. The respondent number 4 in turn had given a part of the contract work to the petitioner. Next paragraph. Though the counsel for the respondent number 2 and 5 submits that the issue pertains to two private parties, and as such the matter should be settled in the civil court, it is seen that the petitioner is acceptable to the settlement of the petitioner's bill amount in terms of the acceptance made by the respondent number 4. While letter dated, respondent number 4, to the tune of rupees 90 lakhs, as can be seen from the letter dated 7/3/2019 issued by the petitioner. So you're acceptable to this amount, no?
Right.
So next para. The above submission made by the counsel for the petitioner makes it clear that there is no dispute with regard to the amount payable to the petitioner. That is rupees 90 lakhs. Next para. Mr. P. Goswami, the learned counsel for the respondent number 2 and 5, submits that the respondent number 2 and 5 are liable to pay to the respondent number 4 an amount of rupees.
Hello, that figure may not be
Yes.
given because I do not have.
An amount of approximately rupees how much? 5.86 crores. However, the same. Where is the DRT order?
DRT and DRAT both.
Whatever, when was the order made?
My lord, last operative part.
However, this is in 2016.
Yes, my lord.
And the stay order passed by this court was when?
14, man.
14.
14, my lord. My lord, we are stuck up.
I know. But did he tell you the amount to deposit?
Yes, my lord, any
Where?
payable, it is written that any payable has to be deposited by so and so account of Punjab National Bank. even they have ordered, DRT has ordered BCPL also not to pay us, but to pay to Punjab National Bank. We went to DRAT and we got that part of the thing removed.
$50 crores.
Yes, my lord. 50 crore, my lord, that is the main, it would, we would be shrinking the, if we.
On the other hand, what about him? They, Punjab National Bank, they write off a lot of loans. This poor fellow has got his only 90 lakhs.
That, my lord, I have no answer. Who has the right? More right, my lord.
That's what.
They should have also agitated there in that, contested this by pleading themselves or whatever it is.
But PNB should have come here also, in the same vein. That way. You also should have implemented them. This is a high court.
Yes.
This is not a tribunal.
Yes.
Then. What have I said? Full stop. However, in view of the judgment dated 11/3/2016 passed by the DRT Guwahati, the money payable by the respondent number 2 and 5 to the respondent number 4 is to be deposited with the Punjab National Bank. Where? Where does it say?
My lord, the defendant number 7 is ordered to make all payment of defendant number 1, if any, through account of defendant number maintained with applicant bank. Applicant bank is the Punjab National Bank. Last page of 32, my lord. Last page, last line.
Last page, last line?
Page number 32.
My lord. Order part, last line, my lord. May I
With
read?
the
my-
Punjab National Bank or through the DRT Guwahati.
Yes, my lord. $62 of the original.
I mean, 49.
Who had gone to an appeal?
My lord, we have gone to appeal.
You have the respondent number 2 and 5.
Yes, my lord.
The appeal made by the respondents number 2 and 5 before the Debts Recovery Appellate Tribunal at Kolkata by the appeal number 55 of 2016 was partly allowed.
My lord, may I intervene, my lord, with apology, my lord? Even in this order, DRD, my lord, if you reads the first line of 33, page 33, DRT order, page 33, last page, first line.
Yes.
Defendant number 8, that is BCPL
Yes.
tracker, is ordered that if any payment is to be made to defendant number 7, that is EPIL, on account of contract number.
Yeah, who's, number 7 is who?
Is EPIL. Myself,
Ah.
2 and 5.
Who is 8?
8 is BCPL. Brahmaputra, that is
That is 3.
yes, my lord.
That is 3.
Yes, respondent.
Ah.
BCPL or on account of guarantee, etc., then the same shall be paid through DRT Guwahati only. So that part we removed it by going to APL.
No, but then why didn't you also make them a party? Or
Wherein, my lord?
in this DRT?
My lord, PNB has made a party to us, thinking that it is, we are the creditors for respondent number 4. That is why they have made party to us. Here the.
But how will this order bind him? He is not a party.
No, this order is binding us, not him.
Correct.
Yeah.
He's not,
So we have the difficulty that I have stated before, my lord. Only.
But so far the liability is concerned. Liabilities of the matter, NAPS, respondent number 4, towards the bank. So, petition number 4 has passed the order.
he has liability towards to you and to the bank. Only problem is DRT has passed an order. So now if we pass an order, there is going to be a clash.
So far,
My lord, it is not only one petitioner. There are other numerous subcontractors. They have filed suit at Dibrugarh. Money suit at Dibrugarh. Only the petitioner has filed writ petition here.
You see, the problem is now the issue is very small. He is acceptable to 90 lakh.
Yes, father.
Now, the only thing that has to be done on your part is you verify whether as work done as per the respondent number 4. That's all. And if he's found eligible to be given that amount, it has to be given. Or it has to go to PNB. There are 2 options.
Yes, sir.
But then that we will come to that bridge.
Decide.
When we will cross that bridge when the time comes. Right now, we will direct you to verify his claim with regard to that 1.36 and where he has agreed to accept 90 lakhs in view of the respondent number 4 limiting his claim to 90 lakhs. You verify that. You have a measurement done. That's all. We will see later on as to whether you have to deposit the entire amount to PNB or minus that 90 lakhs.
Yes.
That is the only way out. Let it be decided by Supreme Court or something like that. We cannot now.
This is not cannot be decided by whether PNB can be paid or him to be paid. We are helpless, my lord.
And
whomsoever our money, their money is there. We whatever is there, wherever my lord would say to pay, we pay.
Okay, whatever I said. Was partly allowed to the extent that if the respondent number 3 was to make payment to the respondent number 2 and 5 on account of the contract work, etc., then the same need not be paid through the DRT Guwahati. Full stop. Correct.
Respondent number 3 to 4 and 5. 2 and 5. Yes.
Need not be paid through the DRT. Full stop. Next. As can be seen from the above facts, the petitioner has accepted the reduction of his claim amount, the reduction of his contractual dues from rupees 1,733 to rupees 90 lakhs, as had been admitted by the respondent number 4. Full stop. Mr. P. Goswami submits that the question whether the petitioner is entitled to the rupees 90 lakhs, as has been admitted by the respondent number 4, would have to be subject to the measurement to be done by the respondents number 2 and 5. First of accordingly, in view of the submission made by Mr. P. Goswami, Learned Counsel for the respondent number 2 and 5, the respondent number 2 and 5 shall cause measurement of the claim of the petitioner and the acceptance with regard to the claim of the petitioner, limiting the contractual dues payable to the petitioner to rupees 90 lakhs. The entire exercise should be conducted within a period of
My lord, it would be at Dibrugarh.
so what?
4 weeks, my lord.
Within a period of 4 weeks. And thereafter submit a report as to whether as to the amount that the petitioner is liable to receive as contractual dues.
Measurements,
Huh?
so for the intimation regarding measurement, that should be made to me, man.
Full stop. The respondent number 2 and 5 shall ensure that they shall inform the petitioner as to the date when the measurement is to be taken by the respondents number 2 and 5, and also intimate the respondent number 4 with regard to the date of verification. List the matter on
Vacation.
after vacation.
My lord, if it is, my lord, my case is fixed at Aizawl bench. So, yes, my lord, so, after 25th.
At least let us be clear about some aspects, that's all.
Yes, my lord.
You measure it, and then we will see whether you have got to give him directly or you have to give to PNB.
That my lord would say.
That we will cross that bridge when the time comes.
Let me know, or prior to 29th or after 29th.
Whenever you give me a date,
27th.
27.
Okay. 28th of. Yes.
20.
Obliged.
Obliged.
Can give this back.